Good morning or good afternoon all. This hearing is in the matter of CFI 009-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Holman Fenwick Willen. Lead counsel is Mr. Sheriff Shivsi KC. The defendants are represented by Jones Day, and lead counsel is Mr. Tom Montague Smith KC. Thank you, Your Honour.
Yes.
My Lord, this is the fourth CMC in this matter, and the parties have agreed an agenda. If I take you to that, it's at page 4106 of our bundle, which is our skeleton argument.
Oh, right. Okay. Yeah.
And there are perhaps a few items where there might be some wrinkles about exactly what the agenda item might cover. But the first few items, which are probably the main event, are agreed. So the first is the parties' progress in relation to their disclosure review. The second is, sorry, my Lord, I'm sorry, I'm taking you to the wrong one. This is the skeleton for CMC. Apologies.
Well, I'm looking at an agenda that says application for vacation of trial date and extension of disclosure deadline, further custodians, keyword searches, audio recordings, etc.
Yes,
is that what I should be looking at?
That's right, exactly.
Right. Well, let me tell you how much work I've done, so we can see how far we're going to get today. I haven't been through the keyword searches in any great detail, so there is really very limited prospect of me dealing with that today, save to the extent that you want to address me on it. Self-evidently, the big item is the question of progress so far, trial date, and date for completion of disclosure. That certainly we will deal with today. Some of the other matters we can deal with probably in the course of that. That's the way I see it for the moment, but tell me if you had further and better ideas.
No, that suits us. I mean, from our perspective, the main event is the trial timetable, and of course whether or not the trial date is maintained or vacated, because we think a lot flows from that. But we don't actually think that when we come to deal with the other items, custodians, keywords, etc., we think that there's a fairly simple route through. And the key point really is that the parties need to get on with their exercises. I say that looking particularly at the defendants, because they're the ones who are, by their own admission, seriously behind schedule. But my Lord, maybe we'll come back to that, because if we could start with really where the parties are.
My Lord, before my learned friend embarks on that, agenda item number 1 is my application to vary the timetable. I mean, I wonder whether it might be worth me making that application. It seems to us there are a number of other issues. There's various discrete issues about the disclosure process, but those will be informed by the question of where we are now, how much more there is to do, and how much whether the timetable needs to change. So I mean, our outline position is, as you all have seen, that we say actually my learned friend gets his punches in early. But we say neither party can realistically be in a position to meet the deadline that your lordship sets.
Yeah, well, I understand that, but Mr. Montague Smith, I understand both sides' positions. I've read the documents on that. It's not really going to make a lot of difference who begins. But are you telling me that in reality we can get through all of this today or not?
I think we can get through, I would hope, the variation application today. So the question of where we are on disclosure and how much more needs to be done and how that affects the trial timetable in broad outline. That those other discrete issues, there's 5 or 6 rather short issues about Mr. Kerman, for example, audio recordings and so forth. I would suggest that those will be unlikely to take us a huge amount of time. If we can fit those in today, we can deal with them today. But it may be that we come back tomorrow for a short bit on that, and then what we can do on search terms, if anything. But we'll take your guidance on what you want to hear from us and how you think search terms ought to be resolved.
Yes. Well, as I say, I haven't been into any detail on search terms. There are two possibilities at the end of the day, aren't there? Either if the disclosure date moves and or the trial date moves, then there may be far more available time for agreement between the parties on search terms, so I don't have to decide anything. Alternatively, when we finish today, having dealt with everything else, I sit down and look at search terms during the course of this afternoon, this evening, and we come back tomorrow and deal with search terms tomorrow. If I take the view that Mr. Shivji is right, all can be accomplished with maintaining the trial date and moving disclosure date by a month or whatever, then we will have to solve search terms, it seems to me, and I will have to do that overnight tomorrow. That's broadly the way I see it.
Understood. My lord, just one suggestion on that, which is this: whatever happens, our view, our submission would be, it would be helpful to have some broad guidance on some of the kind of principled differences between the parties on search terms. Whether or not you get into, I'm grateful.
Floors, ceilings, and caps. I've got that.
Floors, ceilings, caps. Yes, and I'm going to leave that to Mr. Conte to explain what all that means, because I've stayed out of it to an extent. But what I have seen, you understand. Yeah.
You finish, Mr. Montague Smith.
No, please. I interrupted.
Yeah, well, I was saying that I think I can decide those issues of principle today. I think I can decide everything today except for search terms. I mean, realistically, search terms is if I've got to go through what the parties are saying, I need to take time on the individual search terms. I mean, self-evidently, it's a laborious process.
My lord, yes.
My lord, that is our position as well, that you could accomplish it all today. And on search terms, it is quite unusual for the court to have to pick through them one by one. So parties don't normally expect the court to do that. We question actually how useful it is, and our proposal actually allows the court rather sidestep that and allow the parties just to get on with the exercise.
I think we've heard what your lordship has to say about that, and it is, we say, helpful to get some guidance on those points. Your lordship may have seen what happened at the last, and I'll show you it if you haven't, what happened at the last attempt to sit down and have a conversation about this. It was quite hard. My own friend accuses us of delay and so forth, and I'll explain why that is just absolute. I mean, it's quite unbelievable allegation, but there we are. But what happened at the last meeting, when we finally got them to accept that there should be one, the one that your lordship had ordered, is they sat down at that meeting and said, "Oh, well, we're not really here to discuss search terms." A meeting which was ordered to discuss search terms. So we've had some struggle actually to get cooperation. Now you've heard from one side already that this is all our fault, and you may not want to pick the bones of that particular debate, but our position is it would be helpful for your lordship to impose a little bit of discipline on the way in which that discussion is progressing.
Let me say two things at this stage. I mean, for practical purposes, the allocation of blame is neither here nor there. I have to decide what's going to happen to this case in a realistic way. That's the first point, and you can address me on blame if you want to in due course. But let's not focus too much on that at the outset. The second is that, broadly speaking, it is a mistake to let the court decide on search terms, because the court probably knows less about it than any of those who are engaged in doing the exercise in practice on the ground. And the third thing is, and this is what really troubles me about the whole case, is that we're getting to a point where disclosure is the tail wagging the dog, and where a disclosure can take over the whole labours of the parties without necessarily only commensurate benefit.
Well,
the idea that, let me put this quite frankly to you, Mr. Montague-Smith, the idea that when I set a trial date 18 months in advance, the parties could not be ready, just fills me with horror in any case of almost any size. 18 months ought to be sufficient.
Yes,
now we are where we are, and that's what I have to grapple with.
But that's right, my lord. But the reality of electronic documentation is that virtually no disclosure exercises are done in this wide-ranging way, even in London anymore. They will be limited to issues, or they will be done on the various different models that we have in London. The reality of the disclosure exercise that we've been ordered to undertake is that it is a hugely detailed and forensic exercise, which has been approached by the claimant's team in that way. And you're absolutely right. Well, you may be right that it's not about blame, just to deal with those three preliminary points that your lordship made. But that is the way it's put by my learned friend. So I will address you on blame unless it's alleged that unless that position is dropped. Because the way that it is put will colour your thinking, my lord, and it's put in a way which is simply not accurate. And we say it's put in a way which is quite outrageous, and it should never have been put like that. That's the first point. I will make that good, because there has to come a point where these sorts of ways of advancing the case must come to an end, and a certain amount of discipline has to be imposed on it, because it's simply not acceptable the way that case is being put. As to search terms, you're absolutely right. It should not be a matter for the court, but the difficulty that we face and what we see on the horizon is an allegation at trial that somehow there have been deficiencies in the disclosure exercise that's been undertaken, and therefore there ought to be adverse inferences drawn. That's what's being lined up here, and it's naked and it's clear. And so at every turn, no matter how much we do, we will be told we have not done enough and it's inadequate and there must be some hidden document somewhere. And you see that, and one talks about blame, but that is the way that it is put. It's put on the basis that we are deliberately undertaking a defective exercise, we are deliberately slowing down the process. And we do say those are outrageous allegations, but that's what's going to come up at trial. That's why we seek your lordship's blessing for the approach that we propose to undertake, because then we don't have to spend half the trial arguing about adverse inferences arising out of the disclosure exercise. That's where my own friend is taking this case. My lord, but you're absolutely right that this is a vast disclosure exercise. To date, my clients have spent $1.3 million just on the disclosure exercise that's been ordered. And that doesn't include case management conferences, my lord. That's the process of engaging disclosure provider Ernst & Young. That's the exercise of going to Switzerland, searching for the hard copy documents of 54 custodians, and all of those points that we talked to you about in September and then again in October, my lord. So yes, this shouldn't overtake, it shouldn't be the tail wagging the dog, but we have to undertake this exercise in a reasonable way, and that's what we're trying to do. And we're being told we're not doing that, and that's why we keep coming back to the courts to explain that to you and show you what we have done in some detail. So, my lord, I'm afraid we're going to have to spend a little bit of time on what's happened, how we got here, and then look forward to how we're going to move forward, if you'll indulge me with that, because of the way that it's all being advanced. So, my lord, with your permission, I was going to just make my application, if I may, which will involve me telling you about how much we've done, where we've got to, and where we're going forward from here. And then hopefully ask you to take what we would suggest as a realistic view about what can be achieved in the forthcoming weeks and months.
Well, it seems to me it is your application, and however you put it, it is an application to adjourn the trial. So you need to face up to that, as I'm sure you will.
Yes, and I think we have in our skeleton argument. And what we would suggest is we take it in stages. So the first question is, can disclosure work by the current date? If not, how much more time is required? Because I'm sure your lordship doesn't want to make orders and isn't intending to make orders that require us to do things we just can't do, because that would be obviously
the whole point of today. The whole point of today, from my perspective, was to iron out exactly these issues, so that we could be realistic about where we're going.
Yes,
and I've made it plain. I thought that if it's not realistic and if the trial date isn't going to be upheld, the sooner we recognise that, the better, and make provision for it.
Yes, and so a number of things said in my learned friend's skeleton argument. One of them is that is a shadow of a complaint that those of us who represented, who appeared at the CMC in September, were somehow in breach of our professional duties for not raising the point about the length of the trial date at that stage. We're criticised for coming to you too early and too late. So this is what we hope is a realistic and sensible proposal for bringing this claim to trial in a way that is fair to both parties and does justice to the seriousness and gravity of the allegations that are being made, and also the vast quantity of documents that we are having to grapple with in the process. My Lord, just three preliminary points. One, it's said there's been a deliberate go slow of disclosure by my clients. My Lord, I will take you through to some extent the evidence that was served from Ms. Howard and the evidence from Mr. Vallat, none of which is mentioned by my learned friends. In part, the complaint that there's a deliberate go slow seems to be a complaint about what happened before the September case management conference, and I will deal with that. But the presentation of those facts, my Lord, is simply and totally inaccurate. The position is that before that time, the parties, my learned friend says in his skeleton argument for that CMC, the parties agreed to slow the pace of disclosure. In fact, what happens is that defendants agreed, the claimants agreed through Mr. Braganza that the defendants did not need to engage an e-disclosure service provider. So there was agreement about that between the parties prior to the September case management conference. My learned friend says, well, the fact that they didn't appoint, well, you may or may not think that's a good explanation, my Lord. But what that shows is that my learned friend's submission that the failure to appoint an e-disclosure service provider prior to that date was somehow a deliberate ploy to slow down disclosure is simply unfounded. There's no evidence to support it. It's contradicted by the facts, and it is, we say, an absolutely outrageous and very serious allegation that is being made. The claimants know full well why a service provider was not appointed sooner, and it is because they agreed that that should be the position. So my own friend really should not be advancing a case on that premise. It is said that my trial estimate...
I had understood that the parties had WP negotiations. And
correct.
Put very broadly, that was the reason why people didn't get on with things, at least for some of the time.
It was more specific than that. So my learned friend in his skeleton for the case management conference said, and I can show you the page if you like, the parties agreed to slow the pace of disclosure. That is not an accurate and complete explanation of what happened. What happened was that Mr. Braganza, in discussion with my solicitors, agreed that the defendants would not, for the time being, appoint an e-disclosure provider. That was the agreement that was reached. If you want witness statements from my solicitors, we can put that in. I suggest my learned friend checks with his instructing solicitors about what happened at those meetings. The premise of a large swathe of his skeleton argument is that it was a deliberate ploy not to appoint an e-disclosure provider. So I understand that your lordship doesn't want to hear too much about blame, but some very serious allegations are being made by leading counsel and junior counsel on a factual premise that is false. My learned friend also attacks my trial estimate, my lord. And there's this shadow of a complaint about professional misconduct for not raising the point earlier in the September case management conference. And quite how that sort of submission is found to be helpful.
My lord, I can just intervene on this. I'm not and never have made a professional complaint against my learned friends. It's not my style.
No,
so there is no complaint made.
There's no express complaint, but my learned friend makes the submission that it was within counsel's professional duties to bring this up at the September case management conference. That's the way it's put in the skeleton argument. So no, it's not express, but there's implicit criticism on the basis of professional duties. The point of the case that's relied on is that as soon as counsel is aware that the trial timetable or the time for trial or time for hearing is inadequate, then they should bring that to the attention of the court. But why it is put in those terms, personalising it to that level, is not helpful in my submission.
No, but what you do need to face up to, Mr. Montague-Smith, is that I was told by those representing your clients on the second CMC, I think it was, that 2 weeks was adequate. Originally, the position. Let me just finish.
Sorry.
Originally, 3 weeks was what the parties were talking about. I said I hadn't got 3 weeks. I said I could find 2. Was it doable in 2? Mr. Shivji said it was. Those representing your client didn't seriously demur. At the next CMC, I was told in terms by the defendants that 2 weeks was adequate. Now we're told 5 or 6 weeks. And that I find frankly incredible, Mr. Montague-Smith. I can't see any trial before me lasting 5 or 6 weeks of this kind. I also can't see you calling the number of witnesses you're talking about. It just doesn't seem to be to me realistic. And even if you did, how long would they really take? Because their recollection will be limited. This is going to be a case which largely turns on documents, isn't it? And no doubt some slam dunk type cross-examination, if I could put it that way.
Well, my lord, no, I don't. Well, your lordship's obviously extremely experienced in these matters and will have a view on how that's going to work. The way we see it is that there's going to be a lot of documentation, and there's going to be a fair amount of legal argument. And some of that will be novel for this jurisdiction, my lord, because the claims are put in conspiracy, and we will need to look at that in some detail. Now, well, yes and no. I can see where you're coming from.
Law's not that difficult, Mr. Montague-Smith, and
not for some of us. Some of us find it harder than your lordship, I'm sure. But we need to take a little bit of time to look at the documents. And the reason I say that is because a lot of this case is going to be run on inference. And my learned friend's position is that a lot of documentation, that a paper trail has been concealed. So what he's going to be doing is he's going to be picking through the documentary record and piecing that together and saying that fits a map, that these fragments fit the plan that we have in our heads of what the conspiracy is. And so what will need to happen is for each of those fragments, it's going to have to be placed in a bit of context. And very often what that requires is quite a lot, is ultimately the court just going through the chronological run of discrete periods of documentation, because an email here, an email there, which is described in relatively short, brief terms, is completely incomprehensible unless placed in context, and it can have a very different meaning unless you give it that proper context, and that's going to be the case for each of those things. So we're going to have to look through the documents in a bit of detail in my submission. The other aspect is you're right. A lot of this will be on the documents, my lord. But there are 5 parties
in a fairly limited period of time, actually.
Well, I think it's about 2 years, isn't it? That it's alleged that this went on for, and the documentation. I'm sorry. Yeah,
latter half of 2013, working through to end of 2014, and a bit of 2015, right?
Well, I think the allegations start in 2012, as I understand it. But what is said is that the documentation that arises in 2016, for example, is sought because discussions there will be reflective of what happened before. So that there is the prospect of a 4-year period of communications. We've got 54 custodians on our side. We've got 3 individuals as defendants. And we've got then 2 corporations who have individuals who would have been involved at the time. Now, my learned friend is going to have to put his case on each of the facts in a particularised way to each of these individuals, at the very least, So he's going to have to go through every single allegation of conspiracy, breach of duty, agreement, and all of those bits and pieces with each one of those individual defendants. So one can see each of those individuals taking at least a day in the witness box, at least. Now, from the claimant's side, we don't know who they've got. They've got 3 witnesses. And we do consider that we are going to have to expand the roster of witnesses. And that is in part because we anticipate, again, what is on the horizon here, which is going to be an argument about a Wisniewski-style adverse inference argument to say, well, we should have brought more witnesses. The fact that there are relevant people who could speak to these documents, could speak to these facts, are not here, and therefore the court should draw an adverse inference. We see that's again, very obviously, the way that the claimants are going to play this. And so we need to be in a position to put up the witnesses who could reasonably speak to all of this information. So we've got the 3 individual defendants. We anticipate that there will be at least 4 more from the 4th defendant. Mr. Greavy's obviously been identified as someone who is of interest, but I'm not committing to any particular names, but there will be. There's already 4 people who've given evidence in these proceedings, and there will need to be probably a couple more from the 4th defendant who give evidence about the financial side of things to help on the quantum side, how the retrocession works, how the payments and the money side of things work. But also to give your lordship some understanding of the business strategy and the reasons for setting up the 5th defendant and so forth. And in relation to the 5th defendant, at the moment we think 3 or 4 witnesses from them, including possibly, if we can, a couple of relationship managers, but there are already individuals who are targeted as custodians, for example, in relation to the 5th defendant, who will be able to deal with, to some extent at least, discrete parts of these allegations. So we do think we will be putting up, and of course things can change, but this is not just I'm not just trying to pump the numbers here to give an excuse to push this off. These are very serious allegations, and the implications of a negative finding go well beyond financial for all of the people involved, my lord. Your lordships ordered a serious and detailed disclosure exercise because of the nature and gravity of the allegations. And all we're asking for is sufficient time in the trial to be able to actually meet those allegations and take them seriously, and to put up the witnesses who will need to be accused of this very serious wrongdoing, my lord. So at the moment we think looking at about 10 to 12 witnesses from our side.
And are you prepared to name them?
Can I take instructions on that? I don't have any instructions to name them at this stage. I mean, the way we discussed
I
it
understand
previously,
that, and I can't press people to do so. But
I understand.
In any ordinary case management information sheet and so on, I look not only for the number of witnesses, but the identity of the witnesses to see just how realistic it is when people say what they're going to do. So I would be very keen to know who it is. Of course, you're not committed in any way to calling them.
Yeah.
And all it is a signal of current intention, so the court can take a realistic view about what's going to happen.
I understand, my lord, and I will need to take some instructions. I can't read that writing. I'll need to take some instructions, and I'll come back to you on that. But the way it's put against me and the scepticism that I'm faced with suggests that this is just a pure invention intended to solve the problem that's coming down the track right now, and to exculpate ourselves from a difficult situation. We don't think we need to exculpate ourselves from this situation because we don't think it's our fault that we're in this situation. I accept that our thinking in terms of numbers of witnesses has changed. I come to this case relatively late, my lord, and I've done trials in front of your lordship, and I know what that's like. And one of the things that's said against me is, why don't we do it like arbitration? We can all sit long hours and we can do it nice and crunched. And my concern about that, my lord, and we've seen this recently, is twofold. The first is that puts huge pressure on everybody who's involved, from the witnesses to the judges to the advocates to the court staff. And if you're cross-examining,
Montague Smith, I'm not going to sit absurdly long days. I may start at 10 and I might finish at 5, but that would be the absolute outside limits so far as I'm concerned. I don't like sitting long hours in arbitration. I think it's counterproductive.
I agree.
Because in fact, people don't have enough time to prepare what they need to prepare, and in all you do is maunder on without any significant progress being made in the extra time.
I'll take the you in the general sense, but I otherwise agree with the I otherwise agree with the sentiment, my lord. The other point that I would make, my lord, about that is that what one finds in arbitration, and we've encountered this in trials in the DIFC court, is that people don't do the job of cross-examining the witnesses properly. They don't put the case to the witnesses, and so if one takes the trial like Hexagon, my lord, had your lordship found in the judgment to that case, which was a 3-week trial, we did not use all of those 3 weeks, but had the job been done, had time been spent with the witnesses actually doing the job, that would have been a 3-week trial. And that was a trial involving 5 lay witnesses and I think 2 expert witnesses, 1 on each side. In this case, we've got 4 expert witnesses, my lords. We've got a large volume of documentation which we'll need to tell you about, and then we've got the lay witnesses. And on any view, we would suggest you're going to be spending, well, on the current estimate, we've got 8 witnesses, and that's a week's worth of evidence, we would suggest, at the least. On my estimate, we're looking more like 15, which is 2 weeks worth of evidence at the least. And then we've got expert witnesses times 4. We don't know what those times can be. It can take a day to cross-examine an expert witness. It can take more, it can take less. We don't know. But putting aside something like a week for experts, we would suggest is about right. And then you're looking at opening and closing submissions. And this is without any gaps, any breaks for preparation or anything like that for closing submissions. So if we just look about opening and closing submissions, even if you cram that into a week in total, that's 4 weeks right there. Yeah. Now, can this be done in 4 weeks? Yes, I think it probably could be done in 4 weeks, but that would be to cram it into that 4 weeks. And that's why my submission is that 5 weeks would be the right time estimate, and that if one is being cautious and if it makes no difference to the listing, what one would do is list it for 6 weeks with anticipation that you would take some time off, perhaps a week off in the middle, sorry, at the end of the evidence, so that we could come back and give you proper oral submissions on that. Now, you may say that's indulgent and that's far too long, but my submission, this is at the least a 4-week case, and if it doesn't make any, I mean, if it puts the trial back another year, then I could fully understand why you would say let's list it for 4 weeks. But are we going to get this done in 2 weeks? In my submission, no. My lord, progress. Can I? Oh, and the other point that I wanted to make in the outset is there's points about Mr. Greeby that are made again. Now, your lordship made an order requiring him to tell you what he had done in terms of disclosure, and he's done that. And I don't know whether you've read that, my lord.
Yes.
And his evidence on that is very much, I would suggest, not represented accurately by my learned friend's submissions. It's said that he wants to get involved in the disclosure exercise in a way that you have said he shouldn't be involved in the disclosure exercise. In fact, he has made clear he's not giving instructions and has given no instructions about the material that should be included in that disclosure exercise. He's involved simply to the extent, or has been involved simply to the extent of facilitating disclosure by telling us where things are and helping to gain the cooperation of the very many custodians by simply introducing them or escorting them through buildings. He has not said that he wants to be able to direct what is in and what is out. And when we go through the evidence about what has actually been done in the disclosure exercise, it's quite clear, we would say, that this is an independent exercise that is solicitor-led and led by Ernst & Young, the service provider. There's really no room for Mr. Greeby to interfere, even if that's what he intended to do. But in any event, there's absolutely no evidence to support what is now the allegation, which is that he intends to put his hands all over this process. I'll come back to those points as I go through my submissions.
Well, you don't need to come back on Mr. Greeby. I mean, I've read his evidence.
Well, I'm grateful. My Lord, you will have seen on progress then, you will have seen our evidence on progress since the September case management conference. You have two lengthy and detailed witness statements from Ms. Howard and one from Mr. Valat, who is from Ernst & Young. And these explain in detail both what has been done on our side and what more is required to be done to complete the exercise. So I'm going to take you through some of this, I'm afraid, because the suggestion is, my Lord, that the exercise lacks diligence and has been deliberately slow. And we say it's impossible to reach that conclusion on the actual evidence that you have.
Again, Mr. Montague-Smith, I've read Miss Martindale Howard. She's a solicitor. I don't take an evidence from a solicitor as being in any way fictitious. Solicitors know their professional duty, and when they tell me that this is what's happened, I take it at face value unless there's some very clear evidence to the contrary and reason why I should disbelieve them.
Thank you, my Lord.
So you can take it at that level. There are some areas where I need a little bit more clarity, but the essential problems I think have been spelt out. I'm unclear to what extent hard copy documents are still a real issue. Obviously, the audio recordings is a significant point, and I do regard the audio recordings as being potentially important. One of the difficulties about this case, it seems to me, is that the focus on the categories of documents. Because if one's looking for, excuse me, evidence of conspiracies and evidence of subversion of business, as you say, one looks to see what the strategy is that's been adopted, to the extent that's recorded in writing or in telephone records, and one looks to see what actually the RMs did, which again is going to be on telephone as much as it is on paper, probably much more so. And if there is a conspiracy of the kind that Mr. Shivji alleges, parties tend to avoid paper trails if they can. But for disclosure purposes, it seems to me one has to try and identify the categories, the areas of disclosure that really matter. And otherwise, you finish up with a lot of Peruvian guano.
Well, quite, and I mean that is why we've moved away from these kind of simply make disclosure in the old style English style in England, and very often what happens is that you will have a very narrow issue in relation to which that old style disclosure is ordered.
Yeah, exactly.
But that's not the way we've done it in this case. We've got an old style English order which is requiring the search of millions and millions of documents. Now that search has to be reasonable. Well, no, I mean, yes. I'm not, my Lord. That's where we are, and that's
well. My point, and I'm sure I've made this point before, is that there's a need to identify the categories of document that matter, and to be very particular about that, and to be much more cavalier about those areas of categories of documents where, in reality, nothing is likely to emerge that's going to advance anybody's case at the trial. I've talked about in this past, and when we talked about floors and ceilings and so on, I think on the last occasion, I'm sure I made the point, though I haven't been over the transcript, that may be absolutely appropriate in relation to particular types of document where it's pretty clear that nothing significant or nothing critical is going to be involved. You've got to look at each category of documents and decide, is there anything in this that really is going to advance people's cases or not?
Yes. And generally speaking, as I say, when you have such a wide, deep pool of documents, you take a view as to what you think is a reasonable search, but the other side, you lean on them to say, actually, this is what we're really looking for. Now, when it comes to audio recordings, we've got about 7,000 hours of audio recordings. Now, if we transcribe that, it turns into about 200,000 pages of documents. So the idea that we should search that, and the process for doing that is not as simple as saying, well, it takes, as my learned friend's letter last night says, it takes 48 hours to do this transcription, because you have to extract the data by reference to the custodians, which means you have to identify the telephone lines that matter, which means a historical exercise. It's not a straightforward process, and it would take several months to achieve. So we have said it's not reasonable. Now, in the last disclosure meeting, one of the points that said was, well, actually, what we're really interested in is relationship managers for D5. Yeah. That's come up in the last, 10 days? And then,
I would have thought that was blindingly obvious.
Well, then why has that not been said before then? It's never been said before. What's been said before is we got to give you all of it.
I mean, I take a very simplistic view about this, Mr. Montague-Smith. I'm a simple soul. If there were phone calls between the directors that said, let's do this, that, and the other, and made good Mr. Shipji's case, one would want to see those phone calls. Then you would want to see whether the conspiracy had been acted out. And so you'd be looking at the relationship managers and the communications that they were making. Now, at the end of the day, this case is very simple as to what is being said the conspiracy was, and whether or not it was conspiracy between both sides of the fence, as they then were. The shareholders on both sides will split the company, and we'll each take whatever business we can from the company to the detriment of the creditors, or whether it's one side only, in one sense is neither here nor there. But that's the essence of the thing that one wants to be looking for, and then to see how it was acted out if it was.
Of course.
It is actually a simple case in that sense, isn't it?
But finding those documents is not simple at all. So you say, your lordship says, well, if there are telephone calls between directors discussing this, I mean, how are we going to find that unless we say, well, all telephone, we've got to identify what are the telephone lines and therefore the audio files that are associated with those directors. We've then got to find some sort of date range. We've then got to transcribe, we've got to process and transcribe all of that. It is months. And the reality is you have to go day by day looking for each recording by reference to telephone lines. So we've explained in detail in the evidence it's not as simple as just saying, I'm going to go online and I'll just pull out all of the directors' telephone calls, because it's an unstructured database of data. And so we need to follow through with institutional knowledge, find the people who actually know how you put these things together and extract that documentation. So now what's said is we're not looking, in fact, for telephone calls between directors between different dates. What they actually want, they say, and it appears that they're willing to limit their search to this, and that appears for the first time yesterday in the skeleton argument, my learned friend, is they're willing to limit their search to particular dates for the fifth defendant for relationship managers who match a certain description. So they're willing to limit them to, as I understand it, only the fifth defendant's audio, A. B, limited to ex-Bank of Singapore relationship managers, but only those who serviced ex-BSA clients. And C, from the date those relationship managers joined the fifth defendant to the 31st of December 2014. Those are the three limiting factors they offer. The one thing that they suggest in relation to their own...
I haven't seen that.
That's in their skeleton argument. Paragraph 96 of their skeleton argument. So that's new. just so you've got the full list of limiting factors, in relation to their own audio, they say that only calls over 30 seconds in length should be transcribed, but they don't suggest that as a limiting factor for us. And obviously, if it's a sensible limitation, then that also should be applied. Now, we have not had time to figure out how long it's going to take to do the work to undertake that exercise. The best guess we have at the minute is that that's about 4 to 6 weeks as a process, but we just don't know, is the bottom line. We think that the audio from the fifth defendant as a whole amounts to about 3,000 hours of audio out of the 7,000 total. That's in one of our letters. But if we assume that we're extracting something like a third of that material to meet what is being sought, then we're looking at about 1,000 hours. So that there's still a significant process to be undertaken to isolate that data, but that's a 4 to 6 week process. But that is a new suggestion, as I say, that we have not seen before. To some extent, it was trailed in Mr. Braganza's witness evidence, but he wasn't saying we're going to limit ourselves to that. He was giving that as an example of information that they were interested in.
Yeah, well, paragraph 96 says in the first instance. It doesn't limit itself to that.
No, exactly. And I mean, what is said here is that this was said in Mr. Braganza's witness statement. You'll see. Yeah.
Braganza,
The claimants have therefore proposed that in the first instance, but in fact, if you go to Mr. Braganza's statement at page 5140,
yeah,
it's not what he's saying. He says at paragraph 20, defendants provided their information on the 13th of November. The claimant's position is that the fourth and fifth defendants' audio recordings are potentially relevant and should form part of a reasonable and proportionate search.
Yes.
So they're looking for the whole thing, and then they go on to say, in particular, the claimants consider.
Yeah.
So I'm just making the point that this, you know, what's going to be said is that we're making this difficult, but actually the way that this is working is that they're asking for everything, and it's unreasonable. And then we get to court, and the day before we're told actually we can just have this. Actually, this will do. And then my own friend's going to say, well, what's all the fuss about? And all the fuss is about the fact that we've spent the last month arguing about whether we're going to hand them over 7,000 hours of, we're going to search through 7,000 hours of audio data that's going to take us 5 months to process and search. That's part of the reason why we're in this pickle. It's not, I'm afraid, what's being presented, which is that we're dragging our heels and going, as it's put in my own friend's submissions, deliberately slow. So that's where we are on audio recordings. As to their audio recordings, we had a proposal, I think it was last night, from them. And they are proposing to limit their dates. We've got no evidence from them, but they say they will limit the dates of search from the 1st of April 2014 to the 8th of February 2015. And limit it to recordings of 30 seconds or over only.
Sorry, can you repeat that?
Yes.
Can you repeat that?
The date range that they are offering to search is the 1st of April 2014 to the 8th of February 2015.
Oh, yes.
And limiting it to the 30 seconds or over limitation. They say that generates about 299 hours of recordings. We say that date range should extend back and should start at the 1st of January 2014 because it was, we think, in January or February of 2014 when Mr. Walia travelled to Switzerland and announced to the relationship managers that the parties, that shareholders were, quote, divorcing. That appears in, amongst other places, the particulars of claim. And so we say that those recordings are likely to shed light on that part of the process, that part of the history, which is obviously critical to the question of whether or not there was some sort of scheme at that stage. So subject to that, I think that we are happy for them to limit their search of their audio data in that way. But again, this is information we've had last night, which we're reacting to. Up to now, we hadn't been told about this. They previously said they had almost 4,000 hours of audio. So they're proposing to search less than 10% of it. But for now, we are content that should be reasonable. But the 30-second limitation should apply to our data as well, and that may help us bring the time down. So, my lord, you asked specifically about where we were on audio.
Well, it seems to me that's one of the critical areas. But
yes,
and I'd be surprised if Mr. Shipji is really limiting himself to simply the fifth defendant and nothing more. Certainly, as I read paragraph 20 of Mr. Buganza, the fourth and fifth defendants' audio recordings are potentially relevant, and in the context of the fourth defendants and the directors, for the very reasons I've outlined, I would have expected that to have featured high on the list, but maybe I've got that completely wrong.
Well, that's not how it's being put to us today. So we've had two requests, and you might be right. Perhaps this should have occurred to everybody previously, but ultimately, as I say, unless we are to search all of it, we look to the claimants to tell us this is what we're particularly interested in. So we've had that. This is what we're particularly interested in. We've explained why we can't search all of it, and even searching this particular subsection of it is going to be a costly and time-consuming exercise. But what we can't have is a sort of drip, number one, of we'll search this now and come back later. And what we also can't have, we would suggest, is the suggestion that we have in relation to our custodians, which is, well, we're not going to ask for it, we're just going to criticise you for not bringing it up later. And that's what they say in relation to custodians. But I'll come back to those points, my lord. I was going to try to show you some of our progress. You've said that you have read the witness statements, and I know that you have done that in as much detail or more detail than you'd like to. But I would just like to remind you a little bit about some of those, and I'll take it at a very fair clip, if I may, just run through it. So you'll recall, just picking up the story then after the September CMC, so we're at the 23rd of September. And what you get in Ms. Howard's witness statement, I'm going to call her Ms. Howard, hopefully not insult her, she's sitting here, she'll wave at me if I do. Ms. Howard's third statement at page 790 of the bundle and onwards, I'm not going to read it obviously, but she gives a detailed explanation of what was done immediately after the case management conference. Some of this is not represented accurately in my own friend's submissions. So, for example, it said that no instructions were given to EY until the 2nd, I think, of October. But in fact, there is evidence that they took.
I'm very sorry, Miss. Which I printed off Miss Howard's.
Yes, very good.
Statement.
Page 10.
Can you just paragraph, please?
32 and onwards. I wasn't going to show you anything very specific right here, but this is where she talks about taking on Ernst & Young, and the formal engagement took place on the 2nd of October. But you will see there, 4 lines up from the bottom of that paragraph, during the period that is before the engagement, so from early September and onwards, EY took steps to procure and ensure that it would be in a position to assemble the required servers. So preparatory steps were being taken immediately. It's not the case that the defendants just sat on their hands, which is the way that it's being presented. We do say that the claimants have taken difficult positions throughout. So you will see there the complaint that Ernst & Young might not be independent, and that's at paragraph 33. They've subsequently backed away from that, but that inevitably caused problems. There is complaint as well, or there was complaint, and I don't know whether this is maintained, about the use of Nuix by Ernst & Young. In fact, I think you can find that at page 3412 if you want to look at it. We don't necessarily need to go there because it's not clear whether it's it's maintained. But we say that this illustrates what we are facing from the claimant's side. It is not a realistic complaint. The complaint is that we use Newix software. The defendants have appointed Ernst & Young, that they're a very experienced e-disclosure service provider. They've advised us on what is required, and they use Newix globally. Mr. Vallat speaks to that, but instead we've got the claimant's legal team saying that they know better, and they've been told actually we shouldn't be using Newix. That sort of debate just prolongs the exercise and is, we say, extremely unhelpful. Back to Ms. Howard. If we go to paragraph 46, for example, you can see examples of where there have been hold-ups, workarounds have been devised. For example, while the server was being imported, there's a lot of criticism about that process that was taking place. A laptop solution was brought in to help to expedite the process of the data being imported and processed, so that could actually get a head start on that and wasn't held up by the server. And we've got a nice picture of the server. You can see that at paragraph 48 on page 14 as it arrives. This is just a physical representation of the scale of what is being required here. That is what is necessary, and that's the server that then took over the data processing. As to the data repositories that we're dealing with, you can see that starting at section E. So just to have these in mind, my lord, we've got Avaloq, which is the central banking system, and we'll come back to that, but there's about 56 billion entries on Avaloq, and there needs to be some extraction from that. And then there's Hypersuite, which contains the formal document management, broadly speaking, the formal client documents, contracts, transaction notices, and so forth. We've extracted about 130,000 documents from that. Those are part of what we call the non-custodial documentation. There are network drives. You'll see that at 50.3. Those are the H drive and the W drive. I beg your pardon, my laptop is running out of battery. Could somebody make sure that I'm... Thank you. There's the H drive and the W drive. The H drive is a custodial drive in the sense that each individual employee has their own subfolder of that. Too late. No, you need to turn on the... Sorry, I'm sorry, my lord.
This is not working at all.
Are you about to be switched off?
I have been switched off, but I'm speaking through a central speaker. I'd hoped that I would have some electricity, but it seems to be beyond us.
That's why mine's died.
Would you bear with me for a minute, my lord, while I just get this sorted out? Could you get the IT people, please? Excuse me 1 second. Beg your pardon, my lord. I've got power back. I'm just rebooting my laptop. I'm not quite sure why that happened. Yes.
I gathered there were H drives and W drives. I don't know what the W drives are.
The W drive is a shared drive, my lord, shared across the organisation. And essentially what's happened in relation to that is that the whole of the W drive, as I understand it, has been exported. It's about 560 gigabytes of data in relation to that. Right, I'm back up. That's good. That's network drives. Hard copy repositories, I'll take you through a little bit about that, but there's obviously a significant amount of that. That is almost entirely complete. There's a little bit of hard copy documentation that remains to be scanned, but there was a very intensive scanning exercise that was undertaken. So as much of that as possible has been uploaded into the centralized relativity platform. And then there are emails, which of course are the bulk of the custodial documentation. And we've got 54 custodians. Obviously, the custodians go across all of the documents, so that applies both to the emails, hard copy documents, and the H drive. But when it comes to hard copy documents, obviously these custodians are all based in different cities. Some of them are not employed by the fourth defendant or any of its subsidiaries or any of its affiliates anymore. So there's there's also the problem that there's a very large amount of documentation to sort through, because this was a relatively small part of the wider group's business from quite a long time ago now. Problems, of course, arise in the course of this, and just to show you some examples, paragraph 55, which is on page 16 of the document, you'll see that a problem is reference to a problem that arose because this is old data arising from a large number of sources, and so you've got issues that crop up, and Mr. Elie, there's one that arose in relation to his documentation and needed to be fixed. And then there's another example which was picked up by Ms. Howard at paragraph 58. I think what this emphasises is the need for quality control in this process, because Ms. Howard identified that there was a discrepancy between the date ranges of the documentation and the periods of employment of the individuals concerned. And that then meant that because she took the time to catch it, they went back and fixed it.
You're mute.
Yes, sorry, I was giving some instructions off stage. So what we say is that these emphasise the need for care in the process, my lords, and in relation to hard copy documents, it was necessary to speak to each of the custodians to identify where the documents were. So you see paragraph 60 onwards, there's a lot of detail about the arrangements that were made in relation to that, and in particular time-saving arrangements that were made where that was possible without compromising process. If we go forward to paragraph 73, you'll see the approach that's been taken in relation to the fifth defendant. Ms. Howard was on site pretty much every day in relation to that. You see that paragraph 73. And then you have detail about the extraction of the H drives and the fact that we've taken, in relation to the H drives, the date ranges that were from the claimant's proposed search terms. Where feasible, a broader approach has been taken. So, for example, in relation to paragraph 80, this is the point that I was making, in relation to the W drive, the whole of the fifth defendant's data was simply extracted because that was possible. Paragraph 89, if we go forward through to that, you'll see that all ex-BSA client hard copy documents have been extracted, and then there's an extremely expensive and time-consuming process of scanning all of that. And to expedite that process, you see paragraph 92, extra equipment was purchased, and I think extra team members were added as well. But in any event, paragraph 98, you'll see the total process of scanning took about 9 days in total, partly because the team was loaded up and partly because extra equipment was added. Then you had the process of checking through all the other filing cabinets, and we have some more photos to break up the monotony. But at paragraph 103, you can see what was happening there, and this is supported by Mr. Vallett's statement, because he was part of the EY team that was undertaking this. So I'm not going to go through much more of that, but I think.
Well, I'm not quite sure why you're showing me all this, Mr. Montague Smith. All I'm really interested at the end of the day is what remains to be done and how long it's going to take.
Right. Well, I'll come to that. And the reason why I'm showing you this, my lord, is because at the September case management conference, your lord, we were telling you it's going to take us longer to complete this exercise. And you made an order, my lord, which you said, I appreciate you say you can't do this, but if you are going to come back and tell me that you can't do this, I want you to come back with proper evidence showing me that you've taken every step you can to do this diligently and you still cannot comply. And so what I'm dealing with now is that first part of that equation, because my learned friend's case is that we have deliberately slowed down this process. That's the position you will have to take a decision on. Have we deliberately slowed down this process, or have we, as we would put it, taken every step we can to be diligent about this? Now, if my lord, you're happy that we have done that, then I will stop there and I will move on to the process that's going forward. But given that there is that allegation that is made against us, and it is made by senior counsel, so it is a serious allegation that we need to grapple with, then I will deal with it unless you don't need me to, my lord.
Well, why don't you wait and see if that's an allegation that is pursued, and if you need to come back and reply, then you can do that and bore me to death by taking me through the rest of the laborious efforts that have been made.
Well, my lord, these are the joys of a 2-day disclosure hearing, my lord, but we all right, would you just give me one moment, my lord, and I'll skip through the laborious
well, as I say, regardless of blame questions, the real issues that I have to grapple with for practical purposes is the way forward from where we are. So I'm much more interested in what remains to be done. I may have to grapple with all the stuff you've been telling me about, but I may not.
Thank you, my lord. All right, so this is where we are. Let me summarise it now. All right, so this is how we see it. The search terms that are in dispute, and you will hopefully give us some help on tomorrow, lead to different numbers. The claimant's search terms have recently been amended. So until they were recently amended, they resulted in, when run on the custodial electronic documents, about 509,000 documents for us. Our understanding is that the recent revisions may bring that down to about 430,000 documents. So these are custodial electronic documents. Our search terms were at 286,000 results. That's in terms of documents, but that has gone up slightly, we understand, as a result of concessions that we have made. So we're talking about 300,000 custodial. Now, that all will go into CAL, the technology assisted review process, computer assisted learning, I think is the acronym. It is hard to predict how much that will come down, but Mr. Vallat has given some examples, and you can see them on page 856 of the bundle. But just to tell you what they are, he has two examples. One reduced the numbers by 24%, one reduced the numbers by 43%.
Yeah.
So we think we are looking, in our evidence we say 30%, but just for today's purposes, about a third.
Yeah.
So for custodial documents, we're talking about something like 190,000 to 290,000 custodial documents, 200,000 to 300,000, give or take. So that's the starting point. We then have hard copy documents and non-custodial documents. The non-custodial documents are looking like they come in at around, well, all of those actually probably come in at around 500,000 documents. This is before search terms are put in though, because we don't have a set of search terms agreed in relation to non-custodial documents. The 500,000 is broken down like this.
Can I just
Yes.
ask what type of documents these are when you talk about,
Yes.
quote, non-custodial documents? What does that
Yes.
embrace?
Right, so we've got, it's going to break it down. So hypersuite, which is client documentation.
Yeah.
So it'll be contracts and so forth, transaction notices. There's 130,000 of those.
Yeah.
There's then hard copy documents.
But is there anything really going to turn on that?
Well, it's hard to know. I mean, we're told to produce them, to search them. So I don't know.
Well, I mean, a lot of standard form documents isn't going to take anybody anywhere. Contracts. You know, the fact that you're in contract, of course, matters, but the actual contract terms will all be standard form, no doubt, with the odd tweak here and there.
Yeah, I think what's being suggested is that the timing of the entry into contracts may make a difference one way or another. But I agree, the detail of those documents may not be hugely important. But what has happened is we've extracted, as I understand it, the hypersuite documents relevant to the clients for those periods, the relevant clients. Hard copy documents.
Sorry,
sorry.
I keep interrupting you. I know. Non-custodial documents consist of hypersuite client documents. What else?
Yes. So hard copy documents. So actually those will be custodial. These will be custodial as well, but they're hard, custodial and non-custodial, but they're outside of the numbers I've previously given you.
Yeah. I know that.
But those are, so there's about, I think, and this is vague, but something like 10,000 documents for the fourth and fifth defendants that have been scanned and uploaded. Now, when I say, sorry, I don't know what that means.
Non-duplicative, not duplicative of electronic.
It's not been deduplicated. No, you told me earlier it's 5,000. So 5,000, a little bit less for fourth defendants. So something like 9 or 10,000. These have not been deduplicated and they've not been searched. What I would say, though, is that there may be substantial documentation involved, because when I say 5,000 documents for the fifth defendant, those are 5,000 scans. And so it's not impossible that there will be chunks of documentation that has been scanned through. It will all be searchable subsequently. And then the other substantial bit of documentation is the W drive. Yeah. Which is for the fourth defendant, I understand there's about 25,000 documents. For the fifth defendant, 360,000 documents. So that's how we get to about 500,000, a little bit more, pre-search documents. So it's quite hard to know what we're talking about in terms of that. Just for reference, when search terms were applied to the electronic documents, approximately 10% attracted hits in broad terms. It may or may not be the same, and in fact it may be more in relation to these documents, given the search terms, given the nature of the data is client specific, that there may well be more searches. But where we get to on that is on a conservative estimate, once we get out of the CAL process, the scale of the review, the number of documents that we will have to review is likely to be something like 250 to 350,000 documents. And that is obviously without audio, and audio is going to add quite a bit. It's hard to give you accurate numbers on that, but that's broadly where we're at. Now, then the question, and it's going to take some time to get to that stage as well, So we can't start tomorrow. The next question, though, is once we get to that stage, how long is it going to take us to undertake a search of 250 to 350,000 documents? Now, there is a disagreement between the parties about what is an appropriate rate of review to estimate. Now, you'll have your own views on this. My learned friend says 500 documents a day. Now, we say that is not realistic. I'm sure one of us put in a room with 500 documents could get through them in a day, but it has to be sustainable. Anybody who's undertaken one of these lengthy, complex disclosure exercises will know there have to be proper breaks. Otherwise, eyes just glaze over and the whole exercise becomes a waste of money. 500 documents a day is more than one a minute. So if your lordship imagines, if we assume 5 pages per document, you're talking about something like 8 court bundles. If you say the court bundle is 300 pages each. So you're expecting a relatively junior member of the team to read, review, understand, and code 8 court bundles every single day, 5 days a week, for weeks on end. That is not realistic. Our estimate is significantly less. We estimate 200 documents a day, or about 1,000 pages a day. Just to give you that context, that is about 2.5 minutes per document, or about 3 court bundles per day. If you imagine 3 court bundles which across them have 200 different tabs, a relatively junior member of the team is going to have to go through each of those tabs and code every single one of them every single day in a relentless way. So we say our approach is actually punishing. And of course, we have to remember, as I say, not experienced judges doing this. It's going to be mere mortals taking this review process. So if we take the claimant's approach, and we start with what they're looking at, we put it at something like, and there's a bit of maths, and my maths is shifting because the numbers have shifted, but I've come out using their search terms and their results and their rates. It's going to take us about 850 reviewer days. That's my back of a cigarette packet estimate. At our rate, using their search terms, we think we're looking at something like 2,000 reviewer days. And this is only for the first level review, remember. There's no quality control involved in this, there's no second level review, and there's no document preparation, which will have to happen, base numbering, preparing the documents for production. That will take time, just on this scale. If you take the defendant's approach to search terms, then we say we're looking at their rate at about 520 reviewer days, at our rate at about 1,300 reviewer days. And this is all before any audio. And obviously it's possible to mix and match in relation to that. You might assume wider terms and a slower rate or all the rest. As I say, this doesn't take into account any quality control. And if we're going to do this, we should do it properly. It doesn't take into account any second level review or processing or preparing the documents. Now, it's very hard to be precise about all of this, but we say on any view that means the dates need to go back by 3 months at the lower end and 4 months at the upper end. That is a very, very substantial amount of documents to get through. A 250,000 to 300,000 review is going to take 3 months if we could start it tomorrow, realistically, with all the will in the world. I mean, even, as I say, even on their approach, we're looking at about 850 reviewer days. And we've got the intervening Christmas period. Perhaps some people think that people should work all the way through that period. But there are, if one starts at the beginning of next week, about 19 days, if you exclude the Christmas holiday, left before the deadline that your lordship set. So that's the matter. I don't know whether I can help you further on on that. There's other aspects, other pieces of this. There's the audio bit that we've discussed. It doesn't look like they want to add further custodians. We can talk about that in a moment. But that is broadly where we're at, and that is why we say 3 to 6 months. Now, if your lordship is not interested in hearing about whose fault it is that we got to this point, and I say it's not our fault, then we just have to ask ourselves the question, what is a reasonable time for that? Is it realistic? And the temptation is to say, well, if we push people, they can get more done. But the more you push people, the less accurate the process, frankly, and the more you endanger it. And one has to ask, well, why are we rushing this? If we're going to do this expensive and wide-ranging exercise, why would you rush it? Why would you force both parties to rush it? My lord, we do say, and the other point I would make, sorry, is this. All of that is estimates. All of that depends on various unknowns, such as the attrition rate from the technology-assisted review, such as the hit rates on the other documents which haven't yet been searched. And frankly, your lordship needs to be realistic that there is a reasonable chance we will have to come back to tell you again in detail, this is what we've done and it has not achieved the outcome that we're looking for. We have not been able to stick to the timetable that we identified. I'm hopeful that if we set now a realistic deadline, we won't have to come back and do that again. We've already done that process. Let's hold their feet to the fire. Let's see that and your lordship has fairly said, let's see that you're actually doing this diligently. Let's see that you're actually trying hard. All of that evidence that I was going to show you, and some of that I have, was to show you that we've achieved that. We've done that process. Now, if you're satisfied that we are acting diligently and we are going to move forward diligently, then the right approach now, we would suggest, is to take a realistic view of where that is all going to end up and set the deadline for that date. Not say, well, let's keep coming back and keep coming back and keep squeezing the timetable. It's got to be grasp the nettle now, because it will be counterproductive if we do that, not just in terms of cost and time arguing about all of this, but also just on trial date. If the reality is this has to go back by 3 months, if we set a trial date by reference to that now, then we will get the earliest available date for something like that now. If we don't and we leave it for another 6 months, then we won't get the window that might otherwise have been available for everyone's diaries. So that's where we are. Now, on the claimant's side, we've got very little information about what they are doing and what they say they can do. So if you go to, I'll show you very briefly what they say. 773, I mean, compared to the lengthy and detailed explanation, we've got barely anything from the claimants. This is Mr. Braganza's, I think, his 10th witness statement. So this was before last time. No, I'm starting at the 10th, actually. So this is the position on the 31st of October, paragraph 11. So what is said is a disclosure review team has been assembled and briefed. I don't know if you've got Mr. Braganza printed out as well, but this is page 3 of his statement, page 773 of the bundle. Paragraph 11, disclosure review team has been assembled and briefed. Data from the repositories identified in the EDQ was uploaded prior to CMC2 and is capable of being searched. Claimants have also been progressing other disclosure-related work streams, including taking steps to identify relevant audio recordings to be included in the review, considering other potential repositories, and liaising with the defendants about their disclosure exercise. So we received the information about the audio, I think on Sunday night, last night. So that's clearly not been what they've been doing. No other repositories have been explained except for their hard copy documents, and I'll come on to the position in relation to the claimant's hard copy documents in a moment, because they appear not to have been delivered, let alone opened, by the claimants at this stage. and liaising with the defendants is the other task that's identified, which does not require or involve a disclosure team. Mr. Braganza picks up the story in his 11th witness statement. If we go to page 5138, just pausing there at paragraph 10, you'll note he says that to get the metrics, that is the hit rates on the proposed search terms, took about a week for them to undertake. That just gives you a sense of the process. It's not simply a question of putting things into a machine and getting an answer. There are hold-ups at various stages. Now, in this statement, Mr. Braganza says that their actual review was intended to begin on the 21st of November. No doubt my learned friend will tell us what, if anything, has happened in relation to that. I've lost the reference in the witness statement, but I'll come back to that if necessary. So we still don't have search terms finalised.
Paragraph 12.
Thank you very much. So I was in the region. Thank you. Yes, correct. So they're proceeding to the CAL stage, the CAL training stage. They said they were going to start last Thursday, so that's the 21st of November. We worry about that because they don't have the full volume of their documents in that universe. There's no agreement at the moment, for example, on how they're going to deal with their hard copy documents, and it doesn't incorporate any of their audio files. But assuming that that is an accurate process, our estimate is that is a process that will take them 1 to 2 weeks to complete. If that is right, their actual search cannot begin until some point next week. And there are going to be 3 parts to that. There's the electronic documentation, there's the hard copy documentation, and then there's the audio files themselves. Just taking those in turns, just to test their assertion that they can meet this deadline. Paragraph 13 tells you how many documents they get out of their search terms. So this is the minimum. And they've got 300,000 documents. So if we assume a 1/3 reduction from CAL, they are looking at searching manually 200,000 documents. And again, we've got this difference about the relevant, the achievable, reliable rate of search. Is it 500 a day or is it 200 a day? But on their estimates, 200,000 documents at 500 documents a day is 400 reviewer days. So that's an 8-week process for 10 reviewers, something like that. On our estimate of 200 documents a day, that's more like 1,000 reviewer days. A 200,000 document search is a significant and considerable disclosure exercise. The idea they can do that in the time that remains between now and the end of the year is, we say, simply impossible. And of course, if they have to run some of our search terms, that number is going to go up. We have effectively, from the beginning of, or middle of next week, there's around 4 weeks if you ignore the Christmas holidays. So they're going to need, on their estimates, something like 20 reviewers or more just to do the first level review. That's their own rate, their own assessment of documents. It's our estimate of the CAL attrition rate, but there's no competing estimate. And it doesn't take into account any quality control, any second level review, or any time for preparation of the documents for production, or any time off for the team. It also, and you'll see this at paragraph 14 of Mr. Braganza's statement, doesn't take into account foreign language documents. The volume of those is not huge. It's about 14,000, just short. Some of those are non-custodial, it seems. So, but at the moment, those may be quite complicated to deal with and may take a little bit of extra time. So that's just electronic documents. Now we've got to get to hard copy documents. The position in relation to their hard copy documents remains, as we understand it, pretty much unchanged from last time. They have not got them, or maybe they have now, we don't know. They've ordered their delivery, but at least at the time of this statement, had not opened them. You can see what is said about those on page 6 of Mr. Braganza's statement, at paragraph 24 to paragraph 26. That's page 5141. I think they say that they have. Now, we also got a letter, I think, on Sunday night, explaining this in a bit more detail. But I'm going to give you.
They've opened some sample boxes.
They were going to open some sample boxes. I don't think they've got that yet. The position is this. There were, as we understood it, 230 boxes of documents or thereabouts. Those were with a storage provider, Cisco. And what had happened is that the storage provider had produced indexes of the documents in each of the boxes. So those are not produced by lawyers, not produced by anyone associated with the first claimant. Those are just by the storage provider. So what they have done is they've reviewed the indexes, and they have said they think 136 of those boxes are likely to contain relevant documents. And then what they proposed to do was only review those 136 boxes, but then take a sample of 10 of the remaining boxes and check that effectively the indexing was accurate. What we say is they should at least actually look in all of the boxes and try to verify themselves the accuracy of each of the indexes, at the least. And maybe that they don't have to undertake a detailed search of every single box, but they should at least undertake a manual check of all of those indexes. But anyway, assuming that we are just dealing with 136 boxes, a box of documents we think contains about 8 Livre files. You're talking about 2,500 pages of documents, 2,000 to 2,500. If we've just got 136 boxes, they're looking at 340,000 pages of documents. If they have to check through every single one of those boxes, they've got 500,000 pages of documents. So our estimate is that adds, just if you're talking 5 pages per document, another 100,000 documents to their population. But it's 500,000 pages, is because we're talking volume, is we would say relatively accurate. Now, what they say, and you can see this, I'm sure you've read this, at paragraphs 24 to 26 of Mr. Braganza's statement, is that they, I think, were requesting, they first considered whether they should be scanned and uploaded. And they've decided that because that's going to take 2 to 3 weeks, they would do a manual review of these documents. So they're going to manually page turn something between 340,000 and 500,000 pages of documents. And they think they can do that in less than 2 to 3 weeks. Well, we don't know how long they think it's going to take, but they say the 2 to 3 week scanning delay is going to hold things up. Just to pause there, I remind your lordship that we took 9 days to scan in our documents, which were, we think, somewhere between 5,000 and 10,000 documents. So we don't know how long it's going to take them to do all that, but that's what they've been told. Just then looking at the numbers, I mean, if one assumes, as we do, 1,000 pages per day per reviewer, just for the hard copy documents, they're looking at 350 to 500 reviewer days, depending on the volume of boxes that they actually ultimately have to review. This is just for their hard copy documents. We say the answer is surely to scan those documents in and add them to the searches. And there's no explanation for why that hasn't been done to date. It's not like this is a new issue. The 2 to 3 weeks could have been found at any time up to now. It's not said, for example, when the documents were called from storage. But regardless of the blame for why they're in that situation, it is hard to see when you add up the custodial electronic documents and the hard copy documents, how they've got less than 1,000 reviewer days to work on their total review. That's just the maths that we've undertaken. And that's all comes once search terms are settled and once the assisted learning process is complete. Their best case on this, we say, is something like 750 reviewer days. But we say it's much more like 1,500. But how they're going to get away with less than 1,000 days on this, we cannot see. So that's the first two. And then we've got the audio files. And we have been asking for that information for some time. We got the information in the skeleton yesterday, and we've been through this, and they're proposing to produce about 299 hours by limiting the range of audio that they search in the way that we've identified. And then subject to the extension of the date range to January of that year, 2014, we would be content with that. They say they're going to use automated transcription, and a letter came in last night suggesting that would take 48 hours. We don't know whether they've got it segregated in that way. The actual automated transcription process is not the whole sum of it by any means, certainly not from our side, because we have to, as I say, isolate the audio files that are relevant, process them, which takes some time, run the automated transcription, and then do some quality checking, because automated transcription services need to be reliably quality controlled. But in any event, they don't tell us how long they think it's going to take to undertake all of that. But presumably, if they've separated out this 299 hours, then there won't be too much delay, at least in them putting the audio into their system for searching. But we are still presumably on the 299 hours talking about 10 to 15,000 pages of transcripts, something like that. Exactly how long that will take to search is difficult to know. One wouldn't say a page of transcripts is as easy to search through manually as a page of other documents. Quite how the documents are going to be separated out, whether subsections of that 10 to 15,000 pages of transcripts can be isolated, searched through and identified as being potentially relevant, it's unclear because we have very little information about how their data is organised. But we say when you put that all together, their assertion that they can meet the current deadline is fanciful. Yeah, and it's unsupported by any evidence that you will see before you today. And we say also entirely unexplained. It's not explained in Mr. Braganza's statement, it's just asserted. And the skeleton argument simply refers to Mr. Braganza's assertions. We query their ability to meet their own revised deadline, which they suggest should be the end of January. To do a proper search of this volume of material, we say, is not realistic either. So we need, on their approach, to find 850 reviewer days. On our approach, double that. We say it's looking like something between 200 to 400 reviewer weeks, depending on whose rate you take and where you end up on search terms. And that's
how many? I keep having to adjust the days and weeks figures because it's a 5-day week as opposed to a 7-day week. What was the end result you were saying there? 850 review days, or double that at 1,700, gives rise to with 10 reviewers they're thinking of having. What does that do?
For us, I'm back to us. I think they're likely to need about that. They're likely to need about 1,000 reviewer days, which is about 200 reviewer weeks. But that's using their own rates of
that's
review.
20 weeks. Yeah, that's 20 weeks with 10 reviewers.
20 weeks, correct.
Yeah. I've been trying to work it out on what people are saying that the resources are. Yeah, okay.
Yeah, and you can increase the team, but there comes a point of diminishing returns. And they've already said they think 20 is an extremely large team. You have to make sure that the people on the team are properly briefed, and there is a limit to what is reasonable in this context. So I think our disclosure exercise is substantially larger, but that is why we say if we can keep the search terms confined, we need to add at least 3 months to the timetable. If we cannot do that, then we're looking at more like 6 months. In the face of that, we've got this assertion that a short extension will do until the end of January. So, you know, we've done our best. It's all guesswork to an extent, but we have done our best to explain why we think that this is what it's going to take. And we just cannot see that if you extend it by a month, that we won't be back in front of you saying, look, here's all our evidence of what we've done, and it has not been possible to meet that deadline. What is the consequence of that on the trial? And put aside the question of the length of the trial, we can come back to that, but that is material. What is the consequence of pushing back the deadline? It depends how long. If you push it back, how long you push it back, of course. But we say even a short extension, as proposed by my own friend, endangers the trial. Now, you may recall that in September we had a discussion about extending the deadline into mid-February. About the 14th of February, I think, was the date that I was asking for at that stage. And that was before we got a lot more custodians and before we really knew what the metrics were. And my lord, your lordship was sceptical that that would leave enough time in the process for witness statements. I'll just show you what was the discussion was in relation to that very briefly. If you go to page 2805, on the question of whether or not the current we could accommodate the extension to the disclosure deadline that we were seeking and maintain the trial date. Our position was we hope so. Mr. Shivji's position, you'll see at the bottom of page 2805. So he said, in terms of the gaps, do you see this line 42? In terms of the gaps, we think these are sensible gaps, and I would be very reluctant to squeeze them. You know this case having run off track already right at the beginning, at the disclosure stage. I would be very nervous and saying, oh, well, we can compress this timetable. And then over the page, he says, my submission would be that the gap should remain the same. Now, of course, your lordship did compress the timetable already by pushing back disclosure by 2 months. And what your lordship said about this, you can see in 2 pages on, 2808, in the middle of the page, lines 26 and onwards, you say, you're talking about the letters rogatory. And then you say, if you foreshorten that to 2 months for witness statements, which seems to me to be pushing it some, you're still talking about the 10th of April. And then at 2810, you made your decision about all of this at the top right. You say at the end of line 1, my initial view is that it is just possible that this trial date can be maintained, and I'm not therefore prepared to contemplate adjournment now, whilst recognising that there may come a point where that nettle has to be grasped. I also think that there is some possibility of foreshortening some of the steps a little bit. You say, I'll hear Mr. Shivji about what can be done. So that was your lordship's position and my learned friend's position. What my learned friend's proposing now is that having moved the deadline back by 2 months, we move it back by another month. So that would by itself compress the gap between disclosure and witness statements. But then he suggests that we push back witness statements by 24 days is the sum total, just over 3 weeks. So on his approach to disclosure, which is the 31st of January, we would be further shortening the gap. So the gap came down from 4 months to 2 months and a week, and now it comes down, he says, to 2 months, which your lordship suggested was pushing it some last time. And there's 2 points here. One is that we say just adding another month to disclosure doesn't solve the problem. We're going to be doing this for more time than that. But secondly, given the volume of documentation that we are dealing with here, there is a very strong chance that there will be large volumes of documentation which will be produced. And so that will make the prospect of being able to grapple with those documents and figure out how to address them in witness evidence even more difficult. And the idea that we can reduce this to 2 months, we think is going to be difficult. But if you push back disclosure then further than the 1 month, then there's nothing left to compress. And what we would suggest is that if your lordship grasps the nettle on disclosure, you will see that 1 month is not a reasonable extension. And as I've said, part of my learned friend's answer to that is that, well, that's just tough, nothing's changed, it's all our fault, we should keep the dates. And we do say that that is an unrealistic submission, in part because it's not our fault, in part because they agreed that we wouldn't have to appoint a service, an e-disclosure service provider, but in part because of the way that your lordship approached the issue of the deadline last time. And just to remind you of that, it's at page 2816, in line 37. Sorry, line 39. I'm inclined to set you a date to complete disclosure that you say currently is unrealistic. I'm in that sense holding your feet to the fire, and we're going to make provision for further hearings so that the court can be kept updated and you can make such applications as you wish, should those dates in fact prove to be impossible, as you now say. So that's the context in which the order was made at September CMC. And when I asked for a little bit of clarification in relation to this, if we go over the page 2817, and it's line towards the end, the bottom section, where you told me that you thought it was already clear, but you said, I've said I'm making this order on the basis that you're telling me it's unrealistic, but in order to establish that, you're going to have to come along later to show why it's unrealistic. What you've done.
Sorry, I can't see where you're reading from.
I'm so sorry. This is 2817, the transcript, page 48, line 46 at the end of it.
Oh, right at the end. Okay, yes. Okay.
Yes, sorry. I've said I'm making this order on the basis that you're telling me it's unrealistic, but in order to establish that, you're going to have to come along later to show why it's unrealistic and what you've done, and that you've behaved with due diligence, and all has been done that could possibly have been done to achieve the court's order.
Yeah.
So the submission that this has all been decided finally, and therefore we can't come back because we're somehow Henderson abused out of it, we say is misconceived. We provided the evidence that your lordship asked for. We would suggest, demonstrated we cannot reach the disclosure deadline. If your lordship agrees with that, then for our part, there are good explanations for why that's the position. For the claimant's part, we say they can't meet it either, but there's no explanation really as to why that's the position. You've got pure assertion from them instead. My lord, I'm being told to take a break for transcribers, but before I do, I just want to check that I've said everything on this. I mean, if we need to, we do say there's been a change of circumstances. The exercise has developed from something that the scale of the exercise has developed. It is far more substantial than what we originally envisaged. It is outside the norm for this court. Yes, you'd made an order for general disclosure, but we had, and you may say we're right or wrong about this, we had not anticipated the sheer volume of documentation that we would be ordered to gather in that process. And then as to the other point that my learned friend makes, he says it's not fair, effectively, to make them wait for trial. And I've got 2 points on that. First is they need an extension too. But the second point is they waited 7 years to bring this claim.
Yeah.
So it's difficult to assert a particular level of prejudice. Of course, we should proceed as quickly as we can doing fairness to all the parties, but there's no particular pressing urgency. My lord, I'll pause there if that's a convenient moment for the benefit of the transcribers.
Yes, we'll take a break, but can I just hold your feet to the fire for a moment?
Of course.
And ask you, with toes burning, whether what's on your best estimate as to how long it's going to take you to complete your task on your side of the fence. As I've understood it, and from my previous notes, it seemed to me it was a 3.5 months was about the likely period that you thought was best estimate of how long it would take, with ifs and buts that it could be as much as 6 if it really things turned out bad.
Yes, on our search terms, I think. So quite a lot turns on that. Yes. So our best case is about that. The numbers I was giving you, just to remind your lordship, are about first level review of what we think will be the custodial documentation. So that's the sort of bulk of it.
That was that's 2 to 3.5 months for first level review, as I understood it.
Something like that, yes. Is that right?
Oh,
I think it's going to be a little bit longer.
Can you just check your figures and immediately following the break, give me what you say your best estimate is as to the time at which you'll complete your task on the basis of your own estimate as to number of documents per reviewer per day and 20 reviewers that you're putting onto the task. And I want both the figure for the time taken to complete first level review and the time when the job is, quote, complete, unquote.
Yes.
All right. Now, following the break, I want to explore with you the question of letters rogatory requests for foreign court assistance and what you have to say about that.
Thank you. Yes.
We'll take. Right. We'll adjourn till 5 minutes past the hour.
Thank you.
Mr. Shift is with us. Yes, he is.
Very good.
Very good.
All right. So, my lord, I apologise if the maths was not as clear as it could be. It's just the numbers are moving around and my brain is slower than it should be. But I think that the estimate where I came out at for documents, which is a broad estimate, was something like 250,000 to 300,000 documents coming out of that search. So if we're just looking at the first level review, there are a number of parameters there. One is the search rate and one is the number of reviewers. The team on my side was intended to be 20, but that's not all first level reviewers. So there will be some supervision. So actually the first level review team was to be 15, but that's flexible. And of course, when pushed, we can increase that if absolutely required. It leads to more cost and potentially dilution of the knowledge base. But in any event, if one takes 300,000 as the midpoint, then one gets to a range of dates on our review rate of 1,500 reviewer days, on their review rate 600 reviewer days. And if you then apply the different potential teams, 15 and 20, the punchline is it's something like 15 to 20 weeks on our review pace, and on their review pace they come out at 6 to 8 weeks. So there's quite a range.
This is first level only.
This is first level only.
Yeah.
So that's what we. So there is quite a range. I mean, they say, well, if you beef your team up to 20 and do it quickly, you can get it done in 6 weeks, and we do say that's unrealistic. But if you're, there's always room for a range. We do say it needs to be a careful and measured review, and that will require something like, I think what we can say is we would have a fighting chance of getting this review done in 3 months. and depending on where you come out on search terms. So if we're more down at the 250,000 end, then we will have a better chance. If we're up at the 350,000 end, we will have a worse chance. And if the review rate exceeds 200, we will do better than that. But you know, it's always this, when you have a range, one has to pick something within the range, not at the end of the range, and we appreciate that. So we do think that if you get towards the lower number, then the end of March, we have at least a fighting chance of doing it. I do say, though, there is a realistic chance that we come back and tell you that that has not proved to be possible, because things happen, and that's with the best will in the world. So that's the first level review, and there will, if one with a guesstimate says that everything else we can add on, layer on in an additional month or so. I mean that is pushing it some, quite frankly. That's why we say 3 to 6 months.
Yes. Okay. Right.
Thank you, my lord. Then two other things. One is the one that you asked about, which is mutual legal assistance. The other is just to go back very briefly to the question of the trial estimate, and I've been over that. But you did ask me. I don't have names for you. What I can do is tell you why we say what the issues are that these individual witnesses are going to deal with. I think I might have to. I'll revisit that, I think, if I need to. Yeah, I mean, I've given you some indication of who is likely to have to give evidence, and obviously, I won't. I don't think, unless you absolutely want me to, I won't go back to my submissions on the length of the trial estimate. But what we do say is this, just in outline. I think you have it. When you made that order, what your lordship said was, we will have to keep this under review.
Yeah.
And if it turns out we cannot shoehorn this trial into those 2 weeks, then we'll have to think again.
Sure.
And I appreciate the water under the bridge point, but what I would suggest is that shoehorning a substantial, significant, serious fraud trial into what is available is perhaps not the optimal approach in the first place. But if one looks at the way in which the documents in particular and the evidence have developed, well, our submission, I won't give you my beliefs, I'll give you my submission. My submission is that it is not realistic, my lord. Anyway, you've got my submissions on that. Right. Mutual legal assistance, my lord. What we say about this is that if the trial has to go back, it provides us with an opportunity to revisit the question of how we deal with the mutual legal assistance issue. We have filed a report from an independent expert, Dr. Besson. The reason we did that for the purposes of today was because a technical point was taken against us about the independence and therefore the reliability, the evidential value of the report that we had on file beforehand. We are not asking you to decide today that we be released from producing various documents or such documents as we decide to be released from. The point that we are seeking to make good today is that this is a serious issue. And in particular, Dr. Besson has provided us with some statistics on Swiss prosecutions, which show, we say, that these offences are actively prosecuted. And I'll come back to that. But the shape of what we are asking you for at the moment is essentially an order which allows us to make this argument in a proper setting in due course, when we know what documents we're dealing with, and when everybody has had a chance to produce proper evidence for all of this, if it's needed. But in the meantime, not to for us not to be in default of disclosure orders before we've even had a chance to address you on whether or not we ought to be ordered to produce these documents. As to the statistics, very briefly, just so you can see this, and there's not an awful lot that we have to read. If we go to page 5178 of the bundle, what we have is, under the heading 2.2, some limited information that's publicly available about the prosecution rates for certain of the offences. So all we have, you see it at paragraph 123. So he explains it at 122. He makes the point that there's no data for prosecutions under two of the particular criminal provisions, the Banking Act, the Law of Banking, and the Financial Institutions Act. But what there is some data in relation to two particular provisions, sections 271 and 273 of the SPC. And so what that shows is that these are not rarely prosecuted. It's not a lot of them, but there's enough that there is a real risk of prosecution. We've got a total of 52 prosecutions across the period. And if one asks oneself, I mean, I'm not going to get into the full debate on this, my lord, but if one asks oneself, is it reasonable to require a bank to lean on its employees to put themselves in a position where they might well be prosecuted, and all the consequences that flow with that? We would say that there is a real issue there if we are right that some of these documents, if it turns out that some of these documents are covered by confidentiality, bank privacy regulations. That's as far as I need to go, we say, today, to say this is an issue that needs to be taken seriously, because what I'm not asking you to do today is just let us off from disclosing any documents on that. What we're saying is, please don't make an order which effectively finds us in breach for withholding documents up until the point when there's an opportunity to have an argument about it. We can't know the full scale of the problem until we know what the documents are that come out of document searches and the production process. And we can only make the application for mutual legal assistance then. And the point is simply that we should be allowed to wait to have the chance to make that application under MLA, mutual legal assistance. And then if that is refused, or if there's no resolution of that issue by the Swiss courts by a particular deadline, then we should apply to this court for permission to be released from the obligation to produce those documents. So it's not, as my learned friend suggests, that we're asking you just to let us off right now. Now, the order that we've crafted, we can debate, but what we have basically done is we've given ourselves, or we've asked for, 6 months to complete that mutual legal assistance process. The reason we've asked for 6 months is because if you go down to page 5188, that is how long the Swiss process normally takes on average. And Dr. Besson has provided that. It's page 5188, paragraph 4.4, and you will see that his information comes from the Federal Department of Justice. And what he's saying is that the Swiss end takes about 6 months. So the prospect is that we are not going to be able to get through this process within that time frame. But the 6 months will give us the fighting chance to make the application and bring it, hopefully, to a conclusion by the time we have to, or close to the time when we have to come back to this court. So the idea is that we do the disclosure exercise, we produce the, for want of a better word, unrestricted documents, we apply for mutual legal assistance in relation to restricted documents. Now, in principle, there's also a process in relation to witness statements, but we don't propose that we do one exercise and then do the next exercise, because we can overlap those, because we will have seen all of the restricted and unrestricted documents. And so we will be in a position to put together what I would call our restricted witness statement. There'll have to be some degree of delay between the two applications, because we'll want to make our restricted document application for mutual assistance as fast as we can once we've received the documents. And therefore we'll need a bit more time to put together our restricted witness statements and make that application. So we will have to stagger them, hopefully by not too much, and so we don't end up having 2 6-month processes. We have 6 months and then a staggered second process for the statements. And then what we do is we produce statements once all the documents are available, and restricted statements if and when we're permitted to do so, with a long stop to apply to this court to resolve that issue. Now, I think my learned friend accepts, and he says in his skeleton argument, it's paragraph 24, he accepts that a final determination of these issues is not for today. And we agree with that. He raises a series of arguments, but the point is we need the opportunity to make our case about this.
What do you say about the point that there's been a waiver of banking secrecy rules by the relevant clients in paragraphs 15 and 16 and 17?
We don't have evidence. We don't have evidence today to determine, to address that issue. What will I say about it? At this stage, we need to investigate the extent to which those waivers, those contractual terms are incorporated between the relevant clients, whose documents are affected, and the bank. There are different terms for different zones and different areas. My understanding of the Swiss law position is that it is simply not as straightforward as saying, well, there's a general waiver. The question is how the Swiss law courts, in fact, the criminal courts in Switzerland, would consider those terms. And I'm rather like all of us speaking evidence from the bar, if I tell you much more than that. But at the moment, the concern is that the wider the waiver, the less likely it is to be found to be incorporated, or alternatively, the genuine intention was that it would cover third-party litigation of this sort. That's the summary. I don't have the evidence before you today. These points, we would say, are points for another day. Once we know what the documents are that we're dealing with, whose information we're talking about, and then whether or not it is there are other explanations or other ways out of this problem. And we are looking for ways out of this problem. We are looking for answers which will hold up effectively in a Swiss criminal court if they exist, because my clients know full well what the risks will be if we have to come back to you and say to you in 9 months' time or a year, whenever it may be, we simply haven't been able to get permission to release these documents. Those sorts of arguments will be addressed at that stage. I don't have the evidence before you to cover every point that's being raised. My point for the purposes of today is simply this is a serious issue. There's a real risk of prosecution on its face for release of this sort of information. We need the opportunity to have that argument and not have it held against us in the meantime.
Well, it's not really going to be held against you, is it, Mr. Montague Smith? I mean, if you don't give the disclosure, what's going to happen? Mr. Shivji isn't going to be able to come along and say you're in contempt of court when you're making applications and so on and so forth. So I don't really see the necessity for the rather elaborate sequence of orders that you're seeking in your draft.
Well, I'm sure that it can be pared back. First, as to what Mr. Shivji is going to do, one can see a number of procedural applications he might make, striking out.
Well, yes, I mean that there may come a point where we have to have a very big argument about the need for mutual legal assistance and
Yes.
the effect of it and so on and so forth. And
Yes.
but everybody agrees that's for another day.
Yes, but my point is that there shouldn't be, I mean, we want to be frank about what we are doing. So we want to be able to
understand
say
that, and
openly to the court.
if we go through this process, there's going to be time taken. There's no question about that.
Yes, so there's time, but we will be frank if we withhold documents on this basis. We're not just going to say, well, here's our documents.
No, sure.
And that could be met with an application for production of the documents, or an application to strike us out if we don't produce the documents, or whatever it may be.
Well, we'll then have to grapple with all these points.
Well, what I'm suggesting is that we should have the court's indication, at least, and preferably an order, that we will grapple with these points after a certain amount of time, after enough time has passed for us to see whether or not the point goes away because it's resolved by the Swiss courts. That's the issue. And the question, I think, as I understand my learned friend's position, he doesn't object to us taking that process. He says he thinks it can be done very quickly, but I've shown you the evidence which says it's going to take 6 months at least. But subject to that, the only issue between us is what happens in the interim between that time that it might take us to get an answer from the Swiss courts and now. If everyone understands that we're going to go through that process. And so all I'm asking for your lordship to do today is make it clear that that is an authorised way of going about this, one way or another, and that we will not be in breach, retrospectively or otherwise. Because obviously one way it could pan out is we could take the objection and you might decide later on that we were wrong to do so, and then we're on the horns of a dilemma which we're not supposed to be on when we don't know what the resolution is in Switzerland. So that's I think your lordship understands the basic position that we're taking in relation to that. I think, my lord, that is broadly it on the application to adjourn. We've dealt with some of the other issues. We picked some of the other issues up as we went along, audio recordings in particular. But there are the other aspects really affect the claimant's position, the other bits and pieces that are left over. There's one custodian that's left over, and there are a total of 4 information requests. Some of those have been partially answered over the weekend, but there are still gaps in the information that we've been provided with. But it shouldn't affect the timetabling process. So I would propose that we park those for now, unless your lordship wants to hear from me on those.
No, I mean I've got views about those, but are formed on the basis of what I've read so far. But let's leave that for the moment.
Thank you, my lord.
All right, then it's Mr. Shivji on what I call the main point, really.
Yes, my lord. So the 3 points that I wanted to make. Firstly, the trial that the court has ordered remains achievable, and there is sufficient time for disclosure to be completed. The second is the point about delay and that the reasons for the defendants being behind schedule is their own fault. I'll keep that point short because I know your lordship doesn't want to rehearse in detail the history. And my third point is that the court should treat with great caution the revised time estimate for trial put forward by the defendants. Now moving to the first point, which is the main point. We say that the trial that the court has ordered remains achievable and there is sufficient time for disclosure. The first point is that trial would be viable if the disclosure deadline is moved to the end of January. And we say that a proper exercise by the defendants is still achievable over the next few months. Now, just looking at that point about trial being viable if disclosure is moved to the end of January, before CMC2, there was an argument between the parties about what the impact of pushing the disclosure deadline back would be. And my learned friend's position before you was that he wanted disclosure to be put back to late January or early February and only to start his letters rogatory at that point. But he still said to you that the existing trial date was realistic and viable. And if we go to his skeleton argument for CMC2, that's at 3051.
So with reference again.
Page 3051.
Thank you. Yeah.
And it says Jones Day have sought to propose a new timetable which is realistic and sensible. And this is this timetable for disclosure in late Jan or early Feb. And he says, importantly, it will ensure that the parties are able to maintain the existing trial window. Now, we'll come in a moment to whether or not disclosure could be achieved by that on that sort of time frame. But his position then is that a disclosure deadline with that date and with the letters regulatory process only starting at that point in late Jan or Feb, still made a November trial viable. And we say that that was the correct submission, and nothing has changed since CMC2 to change that assessment. And I did say to you on the last occasion at CMC2 that obviously compressing the timetable reduces the flexibility, it makes the timing tight. But our position is that a disclosure at the end of January is still consistent with the trial that the court has ordered. My lord, moving to the next point, whether a disclosure exercise by the defendant is achievable over the next few months. We say it is. And you had a lot of detail from my learned friend on the volume of the exercise, their calculations as to the amount of reviewer days required for their exercise. As with any sort of calculation, it's all dependent on the safety of the assumptions. And there are a couple of assumptions that the claimants have made in their, the defence have made in their analysis, which we say are wrong, and which once corrected make a very dramatic difference to the exercise envisaged. The place to pick this up is Miss Howard's fourth statement at paragraph 116 at 5233.
Yeah. Yeah, this is full of typos, isn't it? In that 115.2 and 116.2 should refer to the defendant's proposed search terms.
No,
I
think it is correct. I think what they're saying is using the search terms that we propose for them, this is what impact it would have. So I
thought 115.1 was to be contrasted with 1.5.2, and likewise 116.1 was to be contrasted with 116.2, using the claims proposed search terms in the first one and the defendants in the second. Each is with no flaw. So that has to be the contrast. Perhaps Mr. Montague Smith will confirm, but that's how I
see your point. Actually, I think that probably is right, my lord.
I think it is right. Which is where I got the 3.5 months and the 2.5 months from.
Yes, no, I'm sorry.
115.2.
Yes, I'm sorry, my lord. You are right about that. Sorry, I was making a different point. But I think you are.
My lord, having invited my intervention, I'm not sure that is right. I think the difference between these two is paragraph 115 is dealing with the review rate of 500 documents a day. So this is about the difference between the review rates.
As I understand, your lordship's point was the difference between 115.1 and 115.2.
Yeah, I don't think you're right, Mr. Montague Smith. You read it again. 116.
Sorry, I've read this a couple of times. I'm so sorry. Give me a moment. I'll clarify with
the difference between 115 and 116 is the rates of review. The difference between subparagraph 1 and subparagraph 2 in each of 115 and 116 on the different rates of review is the search terms that are being used.
Yeah, I think your lordship's correct. That's my understanding. But in any event, well, maybe we'll come back to that particular point, because the point that I was making actually was just about the safety of
Well, it's the assumptions. You want to deal with the assumptions that lie behind it. Yes,
I do. So the first is at paragraph 115. Ms. Howard talks about 10 level run reviewers. Now, actually, as my learned friend just conceded a moment ago, they have a review team of 20, of whom 15 are level 1 reviewers. So it isn't accurate to only use 10 level 1 reviewers here, because by his own admission, they have 15. He also said, tried to attribute to us that we had said that a team of 20 reviewers was extremely large. That point isn't referenced in his skeleton, so I'm not sure where it comes from. But just for the avoidance of doubt, I do not regard a review team of 20 first level reviewers as extremely large. I mean, I've done cases of review teams of 50 to 100 reviewers. They are large. I think for a case like this, a review team of 10, I would say, is small. And certainly on our side, we anticipate that our review team will be bigger than the level 1 review team that the claimants deploy here. And that does make a big difference, because simply if you, for example, double the size of a review team of 30 is perfectly sensible. These numbers fall. If you have a review team of 30, you divide the numbers by a third. So that's the first point. The second point is this point about the review rate. Now, we've used a review rate of 500 documents per day. That is a standard assumption. It's a standard assumption before this court, but also a standard assumption in the English courts as well. And I'll develop that point. Just as regards this court, if you go to 7541,
telling me there is no page 7541.
This was a bundle update.
I only go up to 6798.
Okay, right. Did you receive any bundle updates, maybe by email?
No. I downloaded this yesterday, I think.
Yes, I think this has gone in, I think this morning.
Well, tell me what it says.
I'll tell you what it is. So it's an order made by this court in the SCAT litigation, and in that order, I mean, that was quite a complex review, as we understand it. It was about 900,000 documents in that review, there was an order that the review team should review these documents and code them, privileged and not privileged. And then the order said the review teams must proceed expeditiously, and each individual reviewer should use their best endeavours to review an average of 500 documents per working day. So that was the court's direction, that they use their best endeavours to do that. And as I said, that's a pretty standard assumption, and I'll develop that point.
That was me on the basis of information that someone must have given me.
Yeah,
but
I'll develop it, because we say it's a standard assumption. And if I take you next to an appendix that was part of Lord Justice Jackson's cost review, your lordship, I'm sure, will remember that review. It was complex. It took a number of years, and it reported at a preliminary stage and then at a final stage. And as part of Lord Justice Jackson's preliminary report, he appended a model for calculating the costs of e-disclosure exercises. And that is Appendix 19 of his preliminary report. And that appears in your bundle at 7405. Now, I suspect you don't have that either, because your bundle runs out. I would quite like you to see this document. It's quite useful. Let me just explain what it is, and I'm hoping that someone can email you the parts of the bundle you're missing.
I was just thinking, if I go and have I got enough screens to do all this? Tell me what it says.
Are you able to look on the electronic platform, my lord? It's a cost calculation model.
I don't have these documents either, I'm afraid. My learned friend hasn't actually had the courtesy to send them to me. There we are.
Well, they went in a bundle update to the court, so I wasn't intending to be discourteous, my learned friend. I'm sorry. I had understood it had gone to everybody, of course, including the judge.
Hold on, I'll just have to go to the electronic bundle.
I'm grateful. It should. I'm told. So my solicitors say they've sent it to had sent it to Jones Day, and it should have got on. Should be on everyone's electronic bundles. And this was in our skeleton as well. So I'm not actually sure why my learned friend. Yes, my solicitors have just said it. This went with the skeletons, which were filed yesterday early morning. So I don't know why my learned friend hasn't seen it.
I'm sorry, it seems to be taking forever to come through. Or why? Now, what page do you want?
7405. Has that come up, my lord? Or not yet.
No, it's still downloading itself. I've only got the first few pages, but
Right. I'm sorry.
so this will be in which section of the in the skeleton arguments, will it be, or where will it be?
It's actually one of my. It's attached to my authorities. So it was 7.
In authorities, right.
Legal authorities. It was tab 17. R tab 17.
Okay. Right. Appendix 19.
Yes. This, as I said, is an appendix to the preliminary report of Lord Justice Jackson. And he explains there that 3 cost models are set out. They've been provided by city firm solicitors who are regularly engaged in heavy commercial litigation. the solicitors have produced these models. Sorry, with the aid of the cost estimator software, which they regularly use to predict likely disclosure costs. And then they go on to explain about the variables. And then if you look at the end, last sentence, the small, medium, and huge headings represent the approach of the solicitors concerned. The huge volume example would be very rare, but has been experienced by that firm. And the huge volume, just so that you can see that, is then on the third page, and that is a disclosure review where the review set is 75 million documents. So obviously we're not in the huge territory. And then I wanted to look at the two other models. So the small model is a case where the review set is 15,000 documents, and you can see that on page 7405 on the right hand side, on the bottom table. Does your lordship see that, where it says enter number of documents?
I'm looking at 15,500 number of documents.
Yeah, exactly. So that's what he describes as, or was described there as the small exercise. And then if you go to the next page, there's the medium exercise, and the medium exercise, the number of documents there is 7.5 million. Does your lordship have that?
Yeah.
Now, for each of these models, the review rate is 50 documents an hour. And I mean, here they use an 8-hour day. We've calculated it on a 10-hour day, but that's where you get the 500. Now, whether it's 400 or 500, that we say that is a standard assumption. And also, I mean, this is illuminating because it also gives you the sense of the scale of this sort of exercise compared to the sort of run-of-the-mill exercises. And a medium-sized exercise is 7.5 million documents for review. So that is, probably 30 times the size of what the defendants are having to do. And these are also 2009 figures. So, I mean, over time, numbers have drifted up. I think probably what is a huge exercise has probably moved on since then. So we say that this document's illuminating for both of those reasons. It gets your lordship's eye in as to actually what the scale of this exercise is. And when my learned friend says that this is a very large exercise for these courts, we don't agree with that assessment. And your lordship will also remember Miss Martin's submissions on this back earlier this year, when she said to your lordship that her firm was known for very substantial disclosure exercises involving many millions of documents for review. And essentially her submission was that they know exactly how to run an exercise like this and are capable of doing much, much larger ones. And we agree with all of that, but just taking away those two assumptions that I drew your lordship's attention to, the size of the review team and the review rate. If you apply a review team of 20 and a review rate of 50 documents an hour for 10-hour days, Miss Howard's assessment of 21 weeks for review falls to 21 days. So we say to your lordship that one must have real caution with the defendant's numbers, because actually just small modifications to impose more reasonable assumptions lead to a very dramatic reduction in the number of review days. Now, my learned friend's numbers at paragraphs 115 and 116 of Miss Howard's statement don't take into account email threading and deduplication. And your lordship may be familiar, will certainly be familiar with deduplication, but let me just remind you what those are. So if we go back to the bundle and look at page 3811,
well, I think I know what we're talking about, but go on.
Yeah. So I've just, by way of example, there's an email there from Mr. Walia to a number of individuals at the fourth defendant, a number of those individuals will be custodians. So
Yeah,
one
yeah.
assumes that when their emails are captured, we will get this same email for multiple custodians. And obviously,
Yeah.
when they're deduplicated, that the many emails
Yes,
will
yes,
reduce to
yes.
one. That's the first point. And the second point is the email threading. Each email
Yeah.
in this chain is a separate document, but the
Sure.
technology is very clever and it adds them all together so that when you sit down to read them, you can read the whole thread in sequence rather than having to read all the documents sequentially. So, of course, they haven't run those numbers yet. They're not at the stage where they can work out what the impact of those two techniques will be. But one can envisage in a case like this for custodian data, which is going to be primarily email data, that the application of those two techniques would reduce the review set very substantially. So Ms. Howard's talking about 210,000 documents. Those techniques could reduce that by multiples. We just don't know yet. So, my lord, that's a couple of points on their electronic exercise. Can I just say something also about the hard copy exercise? I mean, it remains to be seen how significant their hard copy exercise is, or indeed the exercise to extract documents from their various databases. But as your lordship said earlier, for a lot of the sort of more voluminous material in this case, it will be obvious from someone having looked at a document for a few seconds whether or not it's relevant or not. If you're picking up a contractual agreement involving a client, you don't need to read the 30 pages of the terms and conditions. You just have to look at the client. Is this a client that's relevant or not? So we say that those sorts of judgments can actually be made very swiftly. And the problem with my learned friend's approach of trying to add up all of the documents and then work out the average review rate is that it rather ignores some of the quick wins that one would have when actually approaching a review in a logical way. And actually, this is something that's covered in Lord Justice Jackson's report when he talks about case studies, that what you do in a review exercise is you have a reviewer who just goes through the easy stuff, the stuff that you can quickly eliminate is either all in or all out. And so it isn't the case that you need to spend 2.5 minutes on every single document. You might find there's 1,000 contracts and they might all be irrelevant, and that's suddenly 1,000 documents out of the pool. And my lord, that just turning, I suppose, to the hard copy exercises, applying that common sense approach, one can see how the hard copy review exercise could be reduced quite significantly. And on that front, I just wanted to have a look at Miss Martin's hard copy search of Mr. Astruc's documents. And we can pick that up in Howard 4 at 5256.
Sorry, reference again?
5256, paragraph 7.3 of Howard 4.
Yeah.
So has your lordship had a chance to read that?
Yeah.
So that's Mr. Astruc's filing cabinet. We're told it's about half full. You get an idea of the size of it from the radiator to its left. And it's actually it looks like a pretty substantial cabinet. We're told it's half full. I mean, it's a sort of broad guess. If it's half full, it looks like each box probably contains about 3 boxes of files. So it's about 15 boxes in total, one would say. Now, applying the mathematics that my learned friend addressed you on in oral submissions, he said for our 130 boxes of review for the claimants exercise, he thought that would take 1,000 reviewer days. So that would be 7.5 days a box. And so for the 15 boxes in Mr. Astruc's cabinet, that would be about 112 reviewer days on his calculation. But as you can see from what happened at 7.3, Miss Martin had a look. in the course of a meeting and satisfied herself that there were no potentially relevant documents in it. And that, we say that is exactly the application of a common sense approach to a disclosure review that on my learned friend's case would take 112 days, but actually can be completed by an intelligent person who's experienced in the course of an afternoon. And that really is how a disclosure exercise like this needs to be conducted, with the application by experienced people of some common sense, not 112 days to go through the contents of Mr. Astruck's cabinet. So my lord, we say that my learned friend's figures don't actually bear scrutiny. They're unfortunately a slave to the mathematics without analysing the logic of the position. And by the measure of Appendix 19 of Lord Justice Jackson's preliminary report, this is not even a medium-size disclosure exercise. It is about 1/30th of a medium-size exercise. It's one that could be completed with a review team of 20 to 30 very quickly. As I said, a team of 20, even assuming that all 210,000 documents needed to be reviewed, could do it in 21 days. And it's for those reasons that we say that this exercise is manifestly still achievable by the end of January. And what is striking in my learned friend's evidence is that they don't actually say anywhere that it is impossible to upscale to get this exercise done in time. And to do the sorts of exercises that Miss Martin addressed you on previously when she talked about mega litigation, those exercises that involve millions of documents. I mean, I totally accept that James Day does have expertise in doing those sorts of exercises. And when they do, they will be reviewing 100,000 documents a month. That's the sort of rate you need to be burning at to get through the material. And it is very demanding running an exercise on that sort of scale, but these top firms do have real expertise in doing it. And I appreciate that you can't just upscale endlessly the size of your review team. And I also recognise that when you get review teams up to the size of about 100, you start to have issues about consistency. But that's not going to be a problem with a review team of 20 or 30. So we say that actually, if the defendants put proper resources into this review exercise, even now, there is every reason to think they would get it done by the end of January. And my learned friend's submissions appeared to be that he said to you that they could do a review of 250 to 350,000 within 3 months if we started tomorrow. That was at page 56 of today's transcript. And we say, well, that I don't doubt that, but we think they could probably get it faster. But also the application of some intelligence to this process probably means they don't need to review anything near that number of documents. My lord, just a few brief words about the levels of review. A lot of the efforts focus on the first level review, but what you do is you run your second level and, if necessary, and your third level checks concurrently with your first level review. So each week your first level review team identifies relevant documents escalation. You have your second level review team ready and waiting. Of course, the number of documents that come out of first level review will be much reduced from the pool. So you're not then dealing with massive volumes, and you just keep that second level review going as you run your first level review. So there really is no reason why the second level review and the third level checks can't complete very shortly after the first level review is done.
I think Mr. Montague-Smith was adding a month to his original 3 months or thereabouts for the first level review. Another month would see the second level review through.
Yeah, well,
that's how I understood him today.
Yeah,
broadly speaking.
I think that's right. But our position is that can be compressed, and I definitely recognise that the exercise has got a tail on it. So even when if we finish your first level review, there is work to be done to close out the second and third level review, and also the technical process of batching up documents ready for production does take a few days as well. So I recognise that those times can't be reduced to 0, but this is a small exercise, and this is an exercise that these firms got real expertise in delivering, and it is simply a matter of turning up the dial. If they need to get it done faster, they could do, and nowhere in the evidence does it say this is simply impossible. We can't do this. This is unprecedented, the rate of work. And of course it couldn't be, because for the mega litigation that Jones Day normally does, this is a month's work. So, my lord, just then moving on just to the quality of the exercise, it's important that the exercise is not watered down. So we were looking at Ms. Howard's fourth statement on the documents from Mr. Astruct. She also deals with the documents from Mr. Sassoon. What is, I don't know if your lordship has had a chance to see what they said, but I can summarise it.
This is in Annex 1.
That was Annex 1, yes. I mean, the essence of it is that neither Mr. Astruct nor Mr. Sassoon have any hard copy documents relating to this matter, and there are no documents relating to the matter on their hard drive, home hard drives, or their network drives.
Yeah.
And I mean, my lord, we say that is a very surprising position, given their seniority within the business and their heavy involvement in the winding down of my client and the creation and setting up of the fifth defendant. As head of legal and the head of a department, you would expect them to have a proper audit trail of what they did. And we're told that there are no hard copy and no soft copy documents on the network or hard drives. Now, of course, we'll see what their email searches reveal, but the fact that they don't have the basic audit trail of the work that they did on what they claim was a bona fide and honest transaction is very troubling. And that is the reason why this disclosure search looks in other pockets in other areas. And I accept, my lord, that inquiry cannot be a roving, broad inquiry. It still has to be targeted and focused. But that is what we are trying to do. We're not trying to put them to vast expense and to produce lots of irrelevant documents, because that doesn't help us. We're trying to actually find the documents that illuminate this case. And we say it is quite telling. We had my own friend, when he was talking about his time estimate for trial, he emphasised repeatedly to your lordship that there will be a large number of documents before the court. And we think that's quite intriguing, because they haven't started their disclosure exercise yet, let alone completed it. And your lordship has seen the documents that were before the court at the strikeout hearing, seen the documentary trail. So we're not entirely sure what this large body of documents is that my learned friend is referring to. But if there is a large body of documents that they know about, then they ought to be giving that as soon as possible. And certainly we ought not to be waiting months for it. So, my lord, then just moving on, that was my first point. So we say exercise achievable by the end of January and the trial still viable at the end of next year. Moving on, my lord, to the whether the defendants are to blame for the present situation. I know that you don't want me to spend time on this, and I'm not going to rehearse the history. I wanted to pick off a few short points, and if you'll indulge me on that, but I will keep it brief. Our first point is that the defendants can't say that they were surprised by what the disclosure exercise involved. And there are 5 sub-points here. First, they have a good understanding of the nature of this case, and they've front-loaded much of the work. They had our particular claim since 2022 beginning. They started their own proceedings in Switzerland in early 2023. And you'll remember from the jurisdiction challenges and the strikeout and summary judgment and all of that, that they are heavily immersed in what this case is about. So there is no sort of last minute revelation on their part that this case is much more complicated than they previously understood. That's my first sub-point. My second sub-point is that they agreed to standard disclosure and certainly didn't dispute it. The third point is that the deadline for standard disclosure was set 2 months after you ordered standard disclosure. And it was set at a point at which the parties had already completed their EDQs and had 2 months to scope out the exercise. and the defendants agreed to the deadline of November in those circumstances, and they must have done so because they believed that it was achievable. My fourth sub-point is that Jones Day have real expertise in running large-scale disclosure exercises, as do the defendants' previous solicitors, that is Clifford Chance and Herbert Smith. My fifth sub-point is that the defendants themselves will have experience in running these types of exercises for regulatory investigations, for example, for FINMA and other regulators internationally. And we can see that from an interchange you had with Miss Martin earlier in the year, where she asked whether she had already had preliminary discussions with her clients about disclosure. And she said that they had, and she said that this was not their, she said they have certainly attended this particular rodeo before, which I thought was an excellent way of expressing it. And just reflects the fact that these sorts of sophisticated business clients will be familiar, even if they're not familiar with litigating in the common law courts, they will be familiar with complex factual investigations because they have to do it regularly for investigative reasons where they're subject to regulators. So that was my first point, my first main point, that they can't be surprised by what the disclosure exercise involved. The second point was this suggestion that the delay in instructing e-discovery providers was because there was an agreement between the parties that the defendants didn't need to appoint an e-discovery provider. Now, as we've just been checking this, that allegation is raised for the first time orally today. It was not a point. It's not a point that's been raised previously. And if you go back to CMC2, and my learned friend's skeleton argument there at page 3050, the reason for the delay was put quite differently.
You're directing my attention to paragraph 3.
I am, yes, my lord. So they reference the settlement discussions, but they say the key reason for the lack of progress was us, and your lordship considered that submission at the last hearing and didn't find favour with it. But there's no suggestion there that the main cause or any factor in the delay in their disclosure exercise was that there was an agreement that they should not appoint a e-discovery provider. And you know, I appreciate your lordship's not going to be able to decide the point today because there's no evidence on the point, and it might be history anyway. But I have clear instructions on that issue from Mr. Braganza that there was no agreement, as my learned friend suggests. And it is striking that there is no document showing any agreement, and if there were, the defence would have produced it. And no reference to the agreement in the defendant's evidence for this hearing either. Now we say it's evident that there's no such agreement as my learned friends suggest, because we of course appointed a disclosure provider. We didn't wait, and it's also evident that the reasons for the defendant's delay in appointing a provider wasn't an alleged agreement between the parties, because they didn't appoint a provider until after CMC2. And by the time we got to CMC2, it was absolutely obvious this case was rumbling on at high speed to trial. And even then, it took them another week before they provided appointed EY. So, my lord, we say there's nothing in this belated suggestion that their entire delay before October can be explained because the parties had agreed that they did not need to appoint a disclosure provider. And they ought to have been progressing their exercise like we were. They ought to have been scoping out the data for collection, ascertaining what repositories there were, who the relevant custodians would be. And having such experienced solicitors on the firm, on the record, such as Jones Day, no doubt their solicitors were telling them exactly what they needed to do. So we do say that your lordship can infer from all of this that it was the client's decision not to appoint an e-discovery provider, that the client decided that for their own reasons, and must have understood the consequences in terms of it likely leading to their inability to comply with the court's directions. And if they had appointed a provider back at the point when your lordship ordered standard disclosure in April, they would have had 8 months to complete the exercise by the end of this year, or 9 months if the extension is granted to the end of January. And look at what my learned friend says about the nature of his exercise. He says he can do a disclosure review of 250 to 350,000 documents in the space of 3 months. So there was plenty of time for a proper and full disclosure review within the time frame that your lordship set. And the reason we are where we are is because the defendants chose not to appoint someone and they chose not to progress their exercise. Now, my lord, that leads into my third point, and I don't need to spend long on this, but your lordship has found repeatedly that there has been a strategy of delay on the part of the defendants, and your lordship has made findings to that effect in 5 judgments. In the extension of time judgment, you found that they were deliberately seeking to delay matters. In the first removal application of Mr. Hayder, you found a strategy of delay. Similarly, in the cost judgment and in the strikeout judgment and in the second removal application. And that it is unusual.
That's all based on stuff preceding October, though, isn't it?
Yeah. Yes, no, my lord. I'm not saying absolutely, and I'm not saying that that necessarily means that they are delaying disclosure now. And I think a lot of my learned friends' submissions focused on the period since the 2nd of October. But the reason that we're massively behind schedule is not because of what they've done over the last 6 or 7 weeks. It's because they did nothing in the previous 5 months. And he has no answer. His only answer to that is that there was this agreement, unwritten agreement, that they didn't have to appoint an e-disclosure provider. And they've chosen not to engage in any of that in evidence. And we say that your lordship can draw an inference that there was foot dragging on their part, and you've seen that strategy of foot dragging in the past. But my lord, wherever one ends up on this,
I can't quite see the point of that. To be frank, though, Mr. Shivji, I mean, this case is going to come on one way or another. It's going to be tried. So what's the benefit in foot dragging once you've had your applications for stay and strike out and everything else decided? I mean, I can't quite see what the motivation would necessarily be.
Well, I see that, but you might say that, my lord, about the application to remove Miss Eason as a liquidator, or to remove me, or to remove HFW, or to oppose the extension of time for service of the claim form, or all of those things, my lord. We've did what we've seen wave after
well,
wave.
I can see all that if you're then going to make life difficult for the purpose of negotiating, see if you can negotiate a settlement. But these parties have had at least 2 goes at negotiating settlements, as I understand it. One during a period in 2022, and then another one this year. The reality is this case is going to go ahead and be fought. That's that. So, yes. I can't see how delay is going to assist, really.
No, well, it may be that part of the strategy also there is to exhaust the claimant's resources, because this has been a surprisingly protracted start.
Well, the Al-Karafis aren't short of resources, are they?
So, my lord, putting all of that together, we say that essentially it is down to them that they are massively behind schedule. And where they are then saying to the court that you must move back trial, looking at the authorities, that's something that the court looks unfavourably on, because they are a victim of the current state of affairs, and they really ought to pull their socks up rather than asking for further indulgence to the court. And your lordship has said it. This is now the 3rd time that your lordship has talked about holding their feet to the fire. And yes, of course, they've got busier over the last few weeks. But I mean, a first level review team of 15 at this stage is just not good enough. I mean, then we say that there is still more resourcing and more effort that they can put in to speed this process up. And then those timescales will really start to fall by many multiples. My Lord, can I just move to the final point, which is my learned friend's revised time estimate for trial? I mean, your Lordship has most of our points on this already. I mean, my learned friend's figures seem to move around. So they said 5 weeks in their evidence a couple of days ago. Then they said 6 weeks in their draft order. The numbers they put forward, we just say don't bear scrutiny. My learned friend says in his skeleton 4 days as a minimum for oral openings. And we just say that is fanciful. Apparently that's by reference to the large volume of documents, although I'm not sure what those are. I mean, your Lordship will know the last time you did a case of the 4-day opening. When I did the autonomy trial, that was 10 months. Openings were listed for 4 days. In fact, no one managed to quite go for that long. So we did 3.5 days of openings for a 10-month trial. In a case like this, 1 day will be more than sufficient. Your Lordship's already highly familiar with this matter. You'll have, no doubt, excellent written openings, and your Lordship will have had a chance to pre-read as well. My experience is that the court nearly always just wants to get on with trial. It doesn't want the advocates to spend lots of time rehearsing the evidence. The judge wants to hear what the witnesses have to say. So we say that 1 day would be sufficient. As to the time required for factual witnesses, your Lordship quite fairly said to my learned friend that he didn't have to commit to calling anyone. All he might want to do is give an indication at this stage of a possible intention. And he went away to think about that and get instructions, but he wasn't willing to share that information. And in fact, he considered, but then ultimately decided not to even address you on the issues that the evidence might cover. And we say all of this is very telling. They tell us that there are going to be 12 witnesses, but we have no idea who they will be or what they might address. In my learned friend's skeleton argument, he appears to indicate that they might be calling the 4 witnesses who've already given evidence on disclosure. That's Mr. Tourette, Mr. Swan, Mr. Gribby, and Mr. Carton. Now, obviously, Mr. Carton and Mr. Gribby are individuals who we will spend time on in cross-examination. But Mr. Tourette's evidence is on disclosure, and he says the reason he's become involved in disclosure is because he had no involvement in this matter at all. So, I mean, the idea that Mr. Tourette's calling Mr. Tourette as a witness is going to materially lengthen trial is unreal. And then, my Lord, the 1 week they've set aside for expert evidence, we just don't understand where that comes from. They've known about this expert evidence for many months. It's difficult to see why their assessment has changed on the time estimate. We say that can be accomplished in a short period of time.
Well, the valuation expert evidence, it may be significant, and it's conceivable that you could cross-examine a valuation expert for a day. I mean, that 2 days is perhaps not unreasonable for the expert evidence on that. On questions of law, if they arise, I'd be surprised if it did last very long. There will be meetings between the experts. They'll come forward with a joint memorandum, and the principles of law, one would be surprised if they're huge areas of dispute. But
I mean, that at this stage, that's our assessment as well. I mean, obviously, it's some time to come, but just looking at how those disputes of foreign law have played out in other cases, our experience is that experts end up agreeing on nearly everything, and there ends up being a fairly small number of areas of contention. So there's no reason to think that that's a week in total. But I agree with what your Lordship said about the valuation. You could have a day expert, and that would be a couple of days in total. And then closing submission. So the defendant's evidence said 7 days in closing. My learned friend, I think, has conceded that 6 is enough, but these numbers are entirely arbitrary, my lord. I mean, your lordship will remember we did the whole case, 82 points of strikeout in 2 days, and in fact we finished early as well. So we just don't see why we're going to spend 6 days closing this, and we don't accept that it is legally complex. So we think that the 2-week time estimate is sufficient. If it is tight and your lordship is able to spare a day or two before the end of 2025, then we could always come back for written closings and then oral closings, and that is, I mean, it's subject to your lordship's diary, but that's often a useful tool. But if your lordship also just wanted to get the whole thing done and closed off within the time estimate, we are content with that too. That may also just be a matter that your lordship wants to reflect on, and we can revisit closer to the time, maybe at the PTR. So my lord, those are my 3 points as to why the current schedule, moving the disclosure date back by a month, is feasible, while the trial is still feasible, while the trial timetable is still feasible. I should just say a word about my client's own disclosure exercise. You have the evidence of Mr. Braganza. He says the court's deadlines are achievable. He is an experienced solicitor's HFW or an experienced firm. We are much further down the track than the claimants. We've accelerated our electronic search processes. We are our CAL learning exercise. I think my learned friend suggested that might be completed in the next week or 2. My instructions are it will be finished today. He asked about our foreign language review and said that he didn't know when that was happening. That is already underway, and we have reviewers in French, German, Dutch, Arabic and Danish looking at those documents. It's right to say that we have prioritised the electronic review over the hard copy review, and that's because we thought the electronic exercise was a bigger mountain to climb, and you've got to start somewhere, and we chose to start there. So nothing turns on the fact that we haven't yet started the hard copy review, but much as Miss Martin used her experience and intelligence to go through Mr. Asterix's filing cabinet, we say that's a process that can be achieved efficiently by experienced people making sensible judgment calls. And in my learned friend's position was that our 130 boxes would take 1,000 reviewer days, and that is just unreal in terms of the resource. That one person taking 5 years of working days to go through the boxes, and that's just not how these things need to work. So we say that obviously can be done much more swiftly with some sense, and it's judgmental. It needs to be done by experienced people who decide what to look at, where an inquiry is no longer worth pursuing. So putting all of that together, my lord, we say that a proposal of 31st of January for disclosure is sensible. It's achievable on our side. My solicitors have heard what I've said today, and they know the importance of adhering to the court's deadlines, and they assure me that we can hit that deadline. The defendants need to have their feet put to the fire again, and they need to be pushed. And as you say, as your lordship says, actually, they're not going to get not very far with delay, and so they really need to now put their shoulder to the wheel. My lord, in answer to Skeleton, I've addressed you on the authorities. I mean, I know your lordship will be highly familiar with how to deal with this. It is an exceptional thing to move the trial. It does matter for the public's perception of actually whether or not a trial date set by the DIFC courts means something or not. It also matters as to whether parties are held to deadlines, because what we see here really is a party who didn't put their foot down at the right stage, put themselves in a position where they couldn't comply, and is forcing the court's hand. And we say the court should not be put to ransom effectively, where it's told you can either have your trial on time, but with a lightweight disclosure exercise, or you've got to put the trial off. Now, my lord, I've got some other submissions on the mutual legal assistance, but is there anything more that you wanted to hear about on the timetable?
Well, I think you need to deal with mutual legal assistance in the context of timetable.
Very good. So on the mutual legal assistance, we don't accept that there is either applicable restrictions or a real risk of prosecution. And although my learned friend's evidence focuses solely on Switzerland, they are apparently running a point in relation to a number of different jurisdictions. And in many of those jurisdictions, they haven't even identified the relevant criminal law, let alone put forward any coherent evidence that there's a genuine risk of prosecution, for example, in somewhere like Hong Kong or Singapore. We say that
It just doesn't arise in relation to Hong Kong or Singapore, does it?
I don't understand. We don't understand their position, and that's why we say that these are just obstacles designed to actually delay them.
I mean, we all know that Switzerland has banking secrecy laws and so on, but I mean, none of that applies in either Hong Kong or Singapore, or at least it would be news to me if it did.
Well, I agree, and yeah, and it's unreal. And also, my lord, I mean, bear in mind that these are points even being taken by the fifth defendant. So a DIFC registered entity. I mean, my learned friend's draft order allows the fifth defendant to not give standard disclosure for a document because it's subject to a foreign law restriction anywhere in the world. I mean, it's unreal. So we just say that this is not for the other jurisdictions is not a meaningful point. As regards Switzerland, the answer is these contractual waivers. That's not the only answer, but that is a simple answer. The defendants know that we put a lot of weight on these contractual waivers. They've been identified by us in our skeleton argument at CMC2, and also we wrote to them in October about all of this. It is very surprising that Dr. Besson does not address this in his report. And he makes it clear in his report that that's not within the scope of the report. And your lordship, I suspect, would have expected them to have addressed that fundamental issue, because if we're right about the contractual waivers, then all of this process falls away. Now, as I said, we're not asking you to decide this today, but we don't want this process to derail the trial. Our present view is that it's likely to be a very small number of documents that are affected, if at all. And I should also say that we don't accept that the whole disclosure exercise needs to wait before the wheels can start turning on mutual legal assistance. But it is incumbent on the defendants to get their skates on and to try and set that up so that it doesn't interfere with the trial of this matter. And we've had hot and cold from the defendants on this. At the last hearing, my learned friend actually seemed to be suggesting, so at CMC2, he seems suggesting that actually they might not even get the order from the Swiss courts. It might be rejected. And we can't form a view on that yet. And certainly my experience is that orders like this can and are made by the Swiss courts. And I've got experience of acting for a Swiss bank where exactly that happened. So we don't accept these are real obstacles. But defendants need to get on with it and get on with it quickly so that it doesn't interfere with the timetable. I think my learned friend backed away from his draft order in submissions by suggesting that the drafting could be fixed. But does your lordship just want to have a look at his draft order on this?
Well, yes, you better make whatever points you want to make.
Yeah, it's at 5273.
Yeah.
And effectively what he seeks to do is to water down your order for standard disclosure.
As matters currently stand, I wasn't proposing to make, regardless of the outcome of the major questions, to make any order of the kind set out in paragraph 8 or 9.
Yes, well, we would.
Seems to me it seems to me these are bridges that. Yes, and 6. It seems to me these are bridges that have to be crossed at a later stage. There may come a point, where disclosure is done, save for objections that are of this kind that then require to be dealt with, in which case, we'll have a significant debate about that in due course. But it doesn't seem to me that that's the basis now for making any order restricting disclosure at all. Mr. Montague-Smith can come back to that if he wants, but at present I don't need to hear you on it. Unless there's something specific you want to raise in relation to it.
No, my lord. I mean, this is the third. I mean, I'll relieve your lordship of the submission. This is the third time we've had this argument about the defendant's attempt to water down this point. So, I mean, we agree. This is not for now. And if they want to apply later on evidence that they have completed their review, and there is a Bank Menat type point which prevents them from disclosing a particular document, they will make that application.
Yeah.
So, my lord, that I think that concludes my submissions on mutual legal assistance and on the timetable generally. My learned friend also did address you on the audio recordings. That is actually later in the agenda, but I think he said what he.
Well, it's part of this. It's part of this debate again, Mr. Shivji, because if audio recordings are going to be an extensive exercise, then it obviously impacts on timetable.
Yes.
Neither party has got any distance on that yet.
So in relation to our audio recordings, this is Mr. Sampson's area, so I don't want to steal his limelight, and I'm going to ask him to come in on the details of the proposals. But on our audio, we have come up with a proposal which very substantially reduces the amount of audio that's needed to be reviewed. We've put it together in a manageable package, and we've made some progress actually in all sorting out the files, what we've got and how we're going to handle it. So we don't think that is I think it's 299 hours that we were proposing to review. We think we can manage that within the timescale. We don't see that that's problematic. I mean, as regards the defendant, I'll let Mr. Sampson come in a moment, but the defendant ought to be able to handle an audio review, because in the various regulatory regimes that they're subject to in many different jurisdictions around the world, there are requirements for audio recording, and audio routinely comes up. Often in the regulatory context, the regulator will want to know what your audio says. That's why you have recorded lines. Oh. So this should be easy for them, because and it's not good enough for them to say it's an unstructured database. They must have the tools available to sort the information, because if the regulator asks, the regulator will not be impressed by the answer. It's in a mess and we don't know. So we don't think that the state of their audio is an answer at all. There needs to be some sensible steps made to marshal the audio. And as your lordship said orally, it can be distilled down, looking at particular date ranges, particular individuals. But if you don't mind, can I hand over to Mr. Sampson on that front?
Yeah.
Good morning, good afternoon, Your Honour. Yes, well, picking up where Mr. Shivji has just left off, which was going to be my first point, these recordings exist because the BSA, D4 and D5 either are or have been at some point regulated financial services businesses, and consequently client-facing telephone lines were recorded. And the claimant's position has always been that these repositories should be included in a reasonable and proportionate review, not least because of the materiality of the evidence that is likely to be uncovered. And the defendants have consistently refused to review their telephone recordings. So if we go to 3581 in the bundle, this was a letter that Jones Day sent on the 29th of October, prior to the last hearing, and it was on the agenda. And if Your Honour goes to 3587, this is an annex of outstanding points that they had raised with the claimants. And on the next page, point 12, is a bare invitation for confirmation of the claimants.
350. Oh, right. In the annex. Right.
Yes, in the annex, Your Honour, and it's at 3588. Point 12. They ask ask the claimants to confirm that they do not need to undertake any search of their respective audio recordings. So the position has always been to just stonewall that sort of request. And if we go to 7075 in the bundle.
What date is this this letter?
29th of October. So it's shortly before the last disclosure hearing with CMC before you.
Yes, go on.
And then if we go to 7075, Your Honour. This is the judgment from the Digicel case. And if Your Honour could just look at paragraph 51 and read down to the third line from the bottom.
Sorry, I have to go to the other screen because it's
Of course.
now page 7,000 and whatever. So 7075, did you say?
Yes, I'm sorry, Your Honour. I've forgotten this is one of the additions.
No, it's just on a different screen, that's all. Where are we going? Oh, come on.
Has Your Honour managed to find that?
I'm sorry, I'm having trouble. I don't quite know why, but
perhaps if I just read the
yes,
point
go
that I
on.
wanted to draw your attention, which is
read it
that
out.
Mr. Justice Morgan said in that case that it is right that the decision as to what is a reasonable search rests in the first instance with the solicitor in charge of the disclosure exercise. And then he goes on to say that if a solicitor whose decision as to what is a reasonable search is later challenged, the court may well be influenced in the solicitor's favour if it sees that the solicitor was very fully informed as to the issues arising in the case, and so on. And the point that the judge was making in that case was that it's initially, at least, for the solicitor who's responsible for the disclosure obligation to form a view as to what would be reasonable. So the point that we make is that it was actually for the defendants to make some proposals about what they thought would be a reasonable search in relation to their audio recordings, which are obviously relevant. And instead, they've just asked us to agree that they don't need to carry out that review. And we say that's unsatisfactory. Moving on to the proposals that the claimants make. Our proposal for our own audio files is to search recordings from the 1st of April 2014 to the 8th of February 2015. The reason for the review is to capture discussions with clients before relationship managers resigned and before they took up employment with D5. And though on our case, such discussions may have been aimed at preparing the clients to move over to D5. And so the date range that we have selected has been informed by that issue in the case. And it precedes the date range in which the relationship managers began to resign from BSA by 1 month, because the first set of resignations was on the 30th of April 2014, and that's pleaded in the particulars of claim at paragraph 56.1. We don't need to go there, but it's at page 31 of the bundle. And it, of course, exceeds the time in which the relationship managers had left. Because of those who went to the fifth defendant, the last date that we've pleaded is the 27th of July 2014, and the defendants have not suggested that any other dates are relevant. And of course, later into 2014, the clients had gone, the business was wound down. So in reality, it's unlikely that there will be many recordings towards the back end of 2014 and into 2015, but there are some, and so we will review them to see what they contain. The claimants have extracted all of the audio files. They had done so by the time of the second CMC in September. Segregation of the phone lines. We've taken the view that segregation of the phone lines would involve a disproportionate amount of work because it would require, on our side at least, manual identification of the owner of each line. So the claimants simply propose to review all of the data within the date range, but we will exclude calls of 30 seconds and under because those calls generally consist of ringing tones. The recording starts as soon as the phone is picked up and the number is dialed. So 30 seconds and under isn't actually going to capture a conversation, or certainly not a conversation of any materiality. The upshot is that we have 5,603 documents to review, which consist of 299 hours of audio. And those are going to be transcribed and translated by an AI tool called Intelligent Voice. A conservative estimate is that it should take up to around 48 hours to process the size of the data that we have. And I'm instructed that we have a separate review team for these recordings. So in my submission, this is a body of documentation that the claimants can get through quite speedily. Now, the only point that arose...
What's your best guess as to when? When you say quite speedily, that doesn't help me a lot.
Your Honour, could I take instructions, because I don't have specific instructions on that point, and I'm hoping that my solicitors will give me that indication. But in any event, if Your Honour is going to push the disclosure deadline back to the end of January, we would certainly come within that. But it may well be sooner. A couple of weeks, I'm told.
Okay.
Now, my learned friend said that we should go back to January 2014 on our recordings, because Mr. Walia announced around then that the shareholders would be divorcing. But we say that's not really necessary. It's too far removed in time from the period when the scheme was actually being enacted, insofar as it touched upon the relationship managers, because our case is that the relationship managers only began to be recruited later in 2014. And the evidence that we have on that is at 3765 of the bundle. And this is an email between Manoj Kapoor, who was one of the team leaders, and Mr. Clinton of BJSS, or BJSS Gibraltar, but he's one of the custodians that the defendants have. And this is about who they'd had a conversation, and Mr. Kapoor identifies people in his team who he considers to be high quality relationship managers. And then he goes on to talk about the compensation. Yes, this is March. So this is obviously a preliminary discussion. And if we go to 3243, this is a spreadsheet that was exhibited by Mr. Devonish in one of his witness statements. And it summarizes the leaving dates and the joining dates of relationship managers. It doesn't identify very clearly who they are, but you can see in the right-hand column who is a client relationship manager. And the third column shows that the resignations begin on the 30th of April, as I have said. So that would be in the third line, for example. And if your Honour reads across, then the sixth column, BJSS AM contract signed date, is the 24th of April 2014. And then the join date is the 1st of June 2014. So we say that this is going on in and around April, really, and that's an appropriate time to start the review of the audio recordings. And we don't need to go back to January. So, Your Honour, those are my submissions on the claimant's audio recordings, and we've put in the order that we should carry out this search along the lines that I proposed. And that's the order that we would invite Your Honour to make. Turning to the defendant's data, if we look at 1148 in the bundle, I would like to show you, this is a contemporaneous document that Your Honour has seen before, but it really highlights the importance of the phone lines. Because if Your Honour looks at the bottom third of the page, this is an email from Mr. Ganju, one of the relationship managers, on September the 1st, 2014. The subject is our discussion. And he says, "Dear Ganesh, it was nice talking to you just now. Please note down my new address details below." And over the page, Your Honour will see that Mr. Ganju is now at BJSS AM. And the response he gets from Mr. Ganesh, Mr. Krishnamurti, is that he acknowledges the receipt of attachments for signature, and the attachments are described at the top of the email. It's the client termination notice for BSA, the new BJSSAM AGBCs, and the client termination notification and communication authorization to BJSS. Those documents appear behind this email. We don't need to go there unless Your Honour really wishes to, but I think that that description tells Your Honour what this email was all about. It was about procuring the transfer of a client from BSA to asset management, and part of that was a phone call discussion. So that would be in D5's audio recordings, and on our case there will be other conversations like that between different clients and different relationship managers. And I think my learned friend said that our request was limited to ex-Bank of Singapore relationship managers. That's incorrect. Our request is for the ex-BSA relationship managers, and there are 3 ex-Bank of Singapore relationship managers who ended up with BSA clients. So that's what our request is for. It's for those relationship managers. And we say that the defendant, the 5th defendant, should review its calls from the date when the first ex-Bank of Singapore RM joined, which we understand would have been earlier than the first ex-BSA relationship manager, because that hiring exercise took place first in time, but we don't know the precise dates. And that should run through to the end of December 2014 to cover the period when solicitation of clients would have occurred, and which is parallel or the same as the date range that is being searched in relation to the relationship manager's emails. So it treats the audio recordings in the same way as the written documents are going to be treated in the defendant's review.
So the date range is?
Well, we don't, this is my point. We don't know the beginning. We have asked in correspondence when the first Bank of Singapore RM who's relevant would have come across. It's at least, I mean, we've seen when the BSA RMs started to join, that was the 1st of June. When we looked at page 3243,
yeah,
the first BJSSAN join date was the 1st of June. But because the Bank of Singapore hiring exercise took place earlier, we think actually you need an earlier date to capture the Bank of Singapore RMs who may have started calling BSA clients up when they joined. Now that deals with the 5th defendant, and as to be clear,
well,
we're not
talking about something around March, April, are we?
We would need the defendant's input on that, but
yes,
that's probably a reasonable.
Well, you've taken the 1st of April. You've taken the 1st of April on your side of the fence. It seems to me it might go back to the 11th of March, but there we are. It's that sort of stage, isn't it, by the looks of it?
Yes.
From the limited information I've seen.
Yes. Yes, Your Honour. And if we had to go back to the 11th of March, that wouldn't be a difficulty because, as I say, we have extracted the data already, so we can do that. Now, the discussion earlier was whether or not we were limiting our request to D5, and we are not. We haven't dealt with D4, but if we go to 617 in the bundle, we can see that D4 has relevant people with recorded lines. So this is a letter that we received from James Day on the 11th.
Page again, Mr. Sampson, forgive me.
617.
Thank you.
So this is James Day's letter of the 11th of October. And they're providing information in relation to the telephone recordings. You can see that from the opening paragraph. They deal first with D4. And on the next page, there is a table of D4's custodians, and it tells us whether or not they had a recorded line. And for the most part, they don't. There are a few people who do. The high priority people in the claimant's view are Alice Brander at the top, Rena Marashley, and Maria Guinea. And Your Honour will, I hope, recall from the last hearing that Alice Brander and Rena Marashley were people who worked in the Swiss booking centre, and they had correspondence with Mr. Philip and Mr. George at BSA about clients who were terminating their relationship with BSA, and they were monitoring who had sent in termination of investment services notices and what their assets under management were, and how that should be reconciled in the fourth defendant's books. And on our case, that's because they were reconciling clients who were moving from BSA to D5. And Maria Ganair was a relationship manager. The defendants plead that she was also Mr. Sassoon's personal assistant. And if your honour goes to page 27 in the bundle, you'll see what we plead about this in paragraph 38.
Yeah.
So we say that Ms. Ganair was in receipt of BSA's confidential information. It was to do with the assets under management and which relationship managers were dealing with which clients. And obviously this is much earlier in the timeline because this is in November 2013. So the claimants are looking at precisely what they should ask for, what they think would be reasonable in relation to D4. But we certainly see that Ms. Sharaf, Ms. Brander, and Ms. Gannett are important people in the case. But there are, if we go back to 618, other custodians with recorded lines who are either involved at the director level in BSA or in D5. And so we will have to take a view as to whether or not we think it's important to include them in the scope of the review. But certainly as a starter for 10, we've put to the defendants that they should search D5's recordings in the manner that I've suggested, and we've put that in the draft order. And obviously the precise date perhaps can be identified with the assistance of the defendants. But in circumstances where we say that the defendants ought to have engaged with this much earlier and ought to have put a proposal forward, they can't now object that we've identified a proposal that's closely tied up with the issues in the case and the evidence that we've seen, and that's what we're asking the court to do. And we think that that will be a narrow review because it's not a very wide date range. It's limited to specific custodians. They ought to be capable of retrieving those recordings for the reasons that Mr. Shivji gave to you. And so we think this is a proportionate and manageable review proposal.
To take the obvious point that I raised earlier, that my first port of call would have been to look for those who were responsible for the strategy and see whether they had telephone calls. I'm just looking down this list at page 618. We see Mr. Carton doesn't have a voice a recording. Mr. Sassoon doesn't. Mr. Greeby doesn't.
You're right. I think the reason for that
doesn't.
I think the reason for that, Your Honour, is that in their capacity as D4 employees, they weren't client facing. But if Your Honour then goes on to 619.
For regulatory purposes, it's the people who are talking to the customers that matter.
Yes, but because they make recommendations about investments. Or they give marketing material, and obviously those are regulated activities.
Okay, and so what were you about to draw my attention to?
So on 619,
yes,
the defendants then deal with D5, and the table starts at the bottom of the page, and Mr. Carton is the last line on that page. So he did have a recorded line with D5.
Yes, I follow. Yes. I see. Yes. Okay.
And I would have to take instructions to double check, Your Honour, but Mr. Carton did have the capacity of relationship manager whilst he was at BSA, and therefore I would expect that he had a recorded line at BSA, and so our own searches are going to capture his telephone calls before he departs.
Yeah, understood.
So Your Honour, we say that all of that's relevant and important to the case. That is a very significant factor for it being reasonable and fair, but it's also proportionate because we're not asking the defendants to review absolutely everything that they have. We've made it quite narrow and targeted, and we've tied it to what is an issue in the case. And we say that's the essence of proportionality.
Yes.
So unless I can assist you on any further on that particular point, those are my submissions on the audio recordings.
Thank you very much, Mr. Sampson. Yes, Mr. Shivji.
So, my lord, I think that brings our submissions on that agenda item 1 to a close, unless there's anything else that we can assist you with. Of course, later in the agenda, there's questions about custodians and keywords and Mr. Gribby, but we can come to all that later.
Well, let me ask you this, Mr. Shivji. Supposing that I thought that this wasn't doable in terms of disclosure and retaining the trial date, it really, once the trial date moves, at the exact timing, I mean, there's no point in shaving off the odd few months, is there?
Well, there isn't, but I mean, it is important that the case is kept roughly on schedule. I mean, I say that for a number of reasons. I mean, litigation does slightly expand to fill the space, and I mean, you see, I mean, this case has had, in my experience, an extraordinary procedural history, one that I've never seen. And there is a concern that in a normal case, you would say, well, all that needs to be done now is disclosure, witness statements, expert reports, and trial. But if your lordship builds more time in to the process, who knows what imaginative applications we will see in many jurisdictions around the world. And so there is a concern that's one concern. I think the second concern is that I mean, with the greatest respect to all the lawyers involved, lawyers do have a tendency to fill the gap with work. So everything the more time you have, the more complicated everything becomes. It's a bit of an excuse for the parties to take more trenchant positions in correspondence, to dig their heels in, etc. Actually, this case now needs to be turning a corner where everyone really has their eyes focused on trial. And in my submission, that's the reason why the scheme of both the RDC and the CPR is to set a trial date early in the procedural context and then hold everyone to it. And we've all had cases where the court has said repeatedly, I've told you what trial is, and you're going to have to hit that trial. Because as soon as the idea of trial becomes a flexible one, where if you're canny enough, you can push it off by a few months or years, then that itself becomes a litigation tactic. So we say for all those reasons, there is good reason to continue to hold the defendant's feet to the fire.
Yes, but let's assume, just the hypothesis I'm putting to you is that October 2025 doesn't hold. If that's the case, it's better to be cautious, isn't it? So that there is no room for any possible future excuse for not retaining a fixed date thereafter, and that enough time is allowed for everything to be done in the interim and in the trial date itself. Meaning duration.
I'm not sure that logic works, my lord, because what will happen, you'll also have seen enough cases to know this, that I mean, there will be lumps and bumps in the road. There just are. I mean, disclosure processes are never straightforward. But I mean, in this case, the most extraordinary alleged obstacles have been raised. For example, these points about the risk of prosecution in Hong Kong and Singapore. So we say, and we would encourage the court ultimately to have a firm grip on the parties, because the only way, I mean, we say that the defendant's tactic is to try to avoid this case ever coming to trial. That has been the single tactic across these proceedings. And if they're successful today in pushing it back, it gives another glimmer of hope that this strategy will work in the future. And this won't be the first occasion on which they are told that actually, regrettably, for reasons outside their control, the timetable is not achievable, or there's some other reason why you can't have the documents that you need before the court. So we say it's a slippery slope. I mean, I take your lordship's point. Your lordship has to form a view on whether it's realistic. And if you're against me, then trial is moved. But we say you don't get there. And if contrary to that, you do get there, I would only be moving it back by a very short period, so that the what is coming down the track is still crystal clear to the defendants, and they don't think they've just pushed it back by a year and this is a trial that's never going to happen.
All right, understood. Yes, Mr. Montague-Smith.
Thank you, my lord. I'll be as brief as I can. Quite a lot of what was said, particularly on audio, hasn't actually been raised previously, and we're working from proposals that were submitted to us last night, pretty much. So, it's not a helpful approach to these sorts of issues, because I can't give you the data on, for example, how long it's going to take to extract various elements. But I'll just take it very briefly in the order that my learned friend dealt with it. And you may not be interested in some of these points, but just to cover them off. My learned friend took you to my submissions in September of this year and suggested that I was saying, yes, we could keep the trial date if disclosure went back to January or mid-February. If you go back to the very next paragraph of that document, it's page 3051. I mean, we did make the point that the timetable is contingent upon the parties completing the disclosure exercise in good time, and then went on to talk about the various variables and difficulties that might emerge, and obviously we say those have emerged. We disagree with the proposition that nothing has changed. As to the calculation, my learned friend said, well, I'm pushing the numbers by bringing in variables which are unrealistic. My learned friend said he wasn't aware of when he had said that a review team of 20 was too large. I think it may have been his learned junior. If we go to page 4109 of the bundle, it is worth looking at this, because this is the position that they took about 20 people. Paragraph 12. So these are I think Mr. Sampson's submissions for the last hearing. And you'll see paragraph 12 in the middle of the page, third line down. They have also appointed an extremely large team of 20 reviewers. As JD acknowledged, this carries with it consistency, quality control issues that the defendants will need to manage carefully. So my learned friend says there's no problem increasing the team to 30, whereas at the time he was saying, well, a team of 20, which would mean about 15 first-level reviewers, was extremely large and risked quality concerns in the process. So we don't accept that this is the sort of case where you should be making the assumption that a 30-person team is the appropriate one. As to the review rate, just picking up 2 points my learned friend made. One was in relation to the SCAT review, and your lordship will recall that the SCAT review was only focused on the question of identifying privileged documentation. So what had happened is that in that search, a very large number of documents had been discovered, and the defendants had simply said they're all privileged. And so a review had to be undertaken only on that discrete issue. In that case, there was then a subsequent issue that was raised by the defendants where they said, oh, well, actually, we've got to do a relevance review as well. We have to do a traditional disclosure exercise, and your lordship refused to undertake that disclosure exercise because it would be too onerous. So my learned friend is not comparing like to like for like there. As to the Jackson review, I don't have the page in front of me, but you were taken to page 7407, which suggested that 400 documents a day was achievable. Note that that assumes a page limit, page number of 3.5 pages per document, which comes out at 1,400 pages a day. And our estimates are based on 1,000 documents a day. Now, that is an estimate that was checked and comes to some extent from Ernst & Young as to what they have experience of. Of course, there is a range, but I just note that the Jackson review was not dealing with the sort of search that we're doing, which post-dates both search terms and computer-assisted learning. It's a raw review. So in our case, we've already filtered out 90% of the documents in those first two phases, and we've arrived at actually more than 90%, because it's 90% with the search terms, and then you take a third off. So you're down to about 6% of the total population of the documentation. You're looking at a much higher hit rate of documents in that. We do say that 1,000 pages a day is about right, but of course there's room for variety there. So when you're considering whether we need an extension, and if so what, We have to be sure that we're comparing the same things, and my own friend is not doing that. The other things he said, which were just wrong, was that the document population I described to your lordship was A, not deduplicated, and B, didn't take into account email threading. Both of those things are wrong. Firstly, page 851, you'll see Mr. Valat's evidence, paragraph 101. You'll see paragraph 101, deduplicated. As to email threading, as I understand it, that is something that is taken into account in the CAL process, and the reference to that is 5236, paragraph 127. So, sorry, it's not in the CAL, but it's built into that deduction that we've incorporated by knocking off a third. So, but regardless, one cannot be too precise about this. My learned friend tries to minimise this exercise, and he somewhat let it slip, because what he said was, if I take it from the transcript of just my learned friend's submissions at page 109, line 15, he said that Jones Day should be reviewing at a rate of 100,000 documents a month. That's what he said. And as I've said to you, we are likely dealing with a population of documents between 250 and 350,000 documents. On my learned friend's submission on that rate, that global rate, you're looking at a 3-month process. His case is that I can easily get this done in 4 weeks. It's not a realistic submission, my lord. One thing that comes out of that is that your lordship said I was adding a month for the second level review. Actually, I'd added a month for the second level review and the third level review and the preparation. Yeah. Thank you. Yeah. But just to and a number of other points emerge. I mean, for example, my learned friend takes some pot shots at the evidence that there were no hard copy documents for two of the witnesses, Mr. Sassoon and Mr. Astruc. So what he's hinting at there is that there are documents, but either they haven't been disclosed or somebody's hidden them away or something like that. He doesn't say it expressly, but that's what he's implying, and that's presumably going to be the submission that's made in due course. Which
well, no doubt they can be cross-examined, can't they?
Well, quite, but
if they give evidence.
Well, quite. Well, that raises the prospect of them giving detailed evidence, not just about the facts of the case, but about these ancillary and peripheral issues, which is going to extend this. What can't be done is that these points are saved up to a closing of a skeleton, where my learned friend says, "Oh well, we don't accept that this, there's a whole load of documents that have been hidden," and rather, as he has done today, just built an inference out of thin air. Well, this has gone wrong, and therefore you can infer that. And the way he puts it, for example, is he says, "Well, we missed the deadline. That there was." He denies that there was agreement that we could not appoint a service provider, and so he builds from that to say, "Well, we've been slow, and that must have come from clients, and therefore there's a deliberate strategy at play to slow things down." Now, that's just an allegation of serious misconduct made on the basis of no evidence whatsoever, dressed up as an inference. And we need to anticipate and plan for the way that this case is being advanced, my lord. And that is what has largely shifted the ground on our assessment of the sorts of witnesses and the number of witnesses that we are likely to need. In terms of the large body of documents that I anticipate at trial, I had understood your lordship to agree with me broadly that that is likely to be the position. My learned friend said, "Well, where are those documents? You should give them to us." And that is clearly not what my submission was. My submission was not, "I've got a trove of documents that's going to help you prove your case." My submission was, if they want to make this case stick, and their case is that this is basically a concealed fraud, then inevitably they are going to have to produce large volumes of documents and try to draw the dots between them, and then we are going to have to place each of those in their context. Nothing like the submission that my learned friend suggested I had made. It is unfortunate, as to this question of an agreement, it is unfortunate that there is a disagreement about whether or not what was in fact agreed during the settlement negotiation. That is obviously an area we wanted to avoid getting into, and our position is we should not have to raise the point at all. If necessary, and if anything turned on it, we are quite willing to provide witness statements and contemporaneous notes of suitably redacted for WP material, notes of the agreement that we understand was made, which was that we would not have to appoint an e-disclosure provider because of the ongoing discussions that were happening. And I remind your lordship that my own friend's own case at the September case management conference was that the parties agreed to slow the pace of disclosure. And that is inconsistent with his case now, which is that there was a deliberate slowdown intended somehow to kick the trial down the line in a way which, frankly, would achieve nothing, as your lordship noted. My learned friend repeatedly, though, continues this theme that there is this very serious misconduct by the party to deliberately slow down, restrict, frustrate the process of disclosure. But on the other hand, in the face of all of the evidence, he's unable to assert a single criticism of anything that has happened on that front since September. And one just sits back from that and says, what is the more likely conclusion? That we have suddenly, we've desperately tried to stop disclosure right up until September and then changed our minds and done it absolutely diligently since then? Or is it, as we say, that the effect of the settlement negotiations, and we say an agreement on this point, was that we didn't get that process started until after WP negotiations had come to their final conclusion? We say it is more likely that we are right on that. As to the trial timetable, I won't go back over that in too much detail. I would ask your lordship just to consider the amount of time that's been spent on case management in these proceedings, and ask oneself the question: is it really likely that we're going to have get through all of this in 10 court days? There will be these additional issues in relation to disclosure, and we will have to consider what we do about all of that. My learned friend identifies Mr. Cart and Mr. Greeby. There are obviously two other individual defendants, and there may need to be relationship managers, but we don't know who they will be. I can go through that if you're still concerned about my timetable, about the sorts of issues that the witnesses are likely to speak to. Amongst them, I've got a list, but I can help you with that if it's useful. We're looking at things along the lines of the fifth defendant's observations about the first defendant after the acquisition took place. Secondly, fourth defendant on the claimant. I do apologise. I'm working from some notes that have been provided to me. There's going to be potentially evidence about the risk to the fourth defendant of the continuing business model of the first claimant in circumstances where there was fallout, in particular with the shareholder. There's going to be the relationship between the fifth defendant and the particular business model which led to its establishment by the group. There's going to be evidence about the winding up of the first defendant's enterprise in the first place. And when I say winding up, I mean the slowing down of the reduction of the business, and the disputes that arose in relation to that between them and the shareholder. There's going to be evidence about the changing business model of the fifth defendant and the differences that there were between that and the first claimant's business model. There will be evidence, no doubt, potentially about the hiring. Well, there will be about the hiring of the Singapore team. There will be evidence about the hiring of former relationship managers employed by the first claimant. Client onboarding has obviously been a topic of much debate, and the audit that occurred in relation to that, that there may, but onboarding generally of clients will be a hot topic. And then in relation to quantum, there are likely to be factual witnesses to assist the court on revenue and on expenses. So there is potentially a lot to cover with the factual witnesses. I cannot give you particular and discrete names at this point because we simply haven't had an opportunity to take instructions during the course of the hearing from the lay clients. But those are the areas, and we do say that 1 to 2 weeks for evidence in relation to that is not unrealistic, and I would say 2 would be the more prudent. In relation to experts, I actually said 4 days, but called it a week because it doesn't make much difference. I think your lordship has landed on 3. I just remind your lordship of some recent experience where, while in arbitration and involving valuation experts, 2 days was what we had. We didn't get through all of the granular detail of the differences. Now, in the end, that didn't make a difference, and one might say, well, we should speed things up in that way in every case. But given a comprehensive approach to those witnesses, one could easily have taken a day and a half with each one. But in any event, we're talking around the margins. If one puts aside 3 days for experts, even with my learned friends, 1 day for openings, we're going to have some closings. We're going to have to tell you about these documents one way or another. And then we need some time for witnesses. Can we fit that into 2 weeks? And my submission, no. And that is important, not just on the basis of do we put this off, but if we do relist this, are we really going to give this a 2-week listing? If the disclosure issues are such that this really has to push back, are we really going to say, no, let's relist this for 2 weeks? I'd ask your lordship just to think about that and speculate as to what would be my learned friend's genuine answer if nothing else turned on it. If the answer was we're looking at pushing the trial back anyway, come on, what shall we give this? I think my answer would be at least 4 weeks, but we would say 5 or 6 would be prudent. On mutual legal assistance, my lord, it was suggested that we are intending to, this is intended to cover the 5th defendant. It's not, it is the 4th defendant which has this difficulty, and it may be that that is simply a drafting issue. I understand your lordship's position. You're not minded at this stage to make any orders specifically in relation to this. I just want to make sure that your lordship has what I'm saying in mind, because what your lordship was saying was, if it turns out that we have documents which we say we cannot produce, then we will simply make the application under Bank Mellet. I think in my submission, what your lordship needs to consider is when you want that application to come on. Do you want that application to come on immediately at that date of disclosure? Or do you want that application to come on after we've had an opportunity to go through the MLA process, the letters rogatory process? And we would suggest much better to have that application at the end of that process. Why? Because it's only then that we know, A, whether there's a problem at all, and B, if there is a problem, what is the scale of that problem? And you need to know that before you can make a decision as to how, what the conclusion is in relation to that. Because it may be that the volume of documentation or the type of documentation that we're restricted from producing is more or less important to the outcome of the trial. And it may therefore be that that is a significant part of the balancing exercise in determining whether or not there should be release in relation to particular documents. It would be an odd thing, in my submission, if we came to you saying, look, we've identified in our disclosure process this broadly described category of documents. We're going to apply to the Swiss court now, but we want you to make an order releasing us in relation to those documents. That, in my submission, would be impossible, really, to get to a final conclusion. So you'd be anticipating us making an application then, at the time of disclosure, saying, we've got these documents, we're making an application under MLA, and please let us off for now, and then come back at the end of the MLA process, if there is a problem that doesn't get solved by that process, and say, well, let us off forever from producing those documents. We can either do it in 2 or we can do it in 1, but if we do it in 1, I would suggest we do it at the end of the process, and then the only question is what happens in between. And my lord, what I would not want to happen is effectively, rather than doing it in 1, we do it, you assume that we're going to do it in one, and then you end up doing it in two because we receive an offensive application from the other side saying, no, hand over those documents for this reason or for that reason. So my submission...
Remind me how the MLA process works. You simply apply to the court on an ex parte basis for request for assistance. Is that how it works?
We need to identify the documents
I understand
with
that.
specificity, but we do not, as I understand it, produce them. And that was my misunderstanding from the September. I hope I don't get this wrong again, because I think I described it as an ex parte process in September, and I don't think it is an ex parte process. We can make the application to the DIFC court to seek mutual assistance from the Swiss courts. And then, so the content is simply passed through. And what the Swiss court needs to see is, with some degree of specificity, the categories of documents that we are dealing with. And the more specific it is, the more likely it is to be successful, and overly broad is unlikely to be successful. So we will be in a position to make that application in, whenever the disclosure deadline is, because we'll have to prepare for that. And so the commitment would be to make that application very shortly after. I believe it is an on-notice application process that we would make, or we can share drafts, as I understand it. It may be that there are bits of it that we cannot share with the defence, but actually with the claimants. Sorry, but actually, my current understanding is that that is not the position, because the nature of the description could not be such as to reveal the confidential information. It would be generic. It's not. It would be to some extent generic, specific, sufficiently specific to identify them. You'd
identify particular documents and describe their general nature.
Yes, but they would have to be particular. So they would, for example, the disclosure process would produce a list of bait stamps. And then we would have to probably provide that list, even if the Swiss court's not actually in a position necessarily to look through each document and decide by reference to that, because we may not be providing the documents. So as I say, you've heard what I had to say on that. I just wanted to make sure that your lordship had understood what I was saying, and the concern that we have, that we just end up in a position where we're, through no fault of our own and without the chance to argue about it, in breach of your lordship's order, which of course we don't want to undertake. I've been told that the transcribers need a break. I did want to deal very briefly with audio. I don't know what to do about that. I've got sort of 2 or 3 minutes on audio. It may be a little bit longer. I can finish that now, or we can take a break. I'm in your hands.
Well, if you've got a message, transcribers need a break, we better take a break.
Well, thank you.
1:30, please.
Thank you.
Yes, Mr. Montague-Smith, if you're ready.
Yes, my lord. Thank you. Just very shortly on audio. The 2 issues, our audio and their audio. In relation to our audio, I didn't take you to it, I don't think, but we have evidence about what collating our audio will require. And we relied on it. I think I summarised it, but the mechanics of it are, well, firstly, the review of what there is, you'll see in the letter, page 4874, paragraphs 4.3 to 4.6. I've summarised this for you. And then the mechanics of what would involve to undertake the search are set out at page 5225, paragraph 79 to 83 of Ms. Howard's 4th statement. Now, in response to that, my learned friend says, well, they know better, because the regulations, which they haven't shown you, require us to keep these recordings in a certain way, such that they're easily disclosable. I don't know what the regulations say, and I don't think your lordship does either, and it sounds like my learned friend isn't entirely clear on the detail of that either. We don't agree with the summary. Our understanding is that there's an obligation to keep recordings of client instructions, but I'm not aware, at least, sitting here in front of you, of any obligation to keep that data in any particular form. The difficulties that we are facing in relation to this are very clearly illustrated by Mr. Sampson's submissions. One thing he said about his own data was that it would be disproportionate to segregate by reference to individuals, because that would require manual identification of telephone lines. Now, if that is the case in relation to the first claimant, imagine that the problem when one looks at the fourth and fifth defendants as a whole, because their businesses ranges much more widely than
well,
the first claimant.
my note, Mr. Montague-Smith, of what your evidence shows in the fourth witness statement of Miss Howard is collection and transcription 2.5 to 3.5 months, plus review of 9 to 10 weeks.
That's of all of it.
With the conclusion that that is disproportionate and unreasonable.
Yes.
And so the question which arises is, given a more limited scope of review, what time is it going to take? And the answer is you haven't had the time to provide that information.
That is right, but the problem is illustrated by my own friend's approach, because so we go from this, we want everything, to this rather more confined. But then in the course of his submissions, Mr. Sampson takes you to page 618 and points you to some of the names on the list identified by the fourth defendant and says, well, we quite like Miss Alice Brander, Maria Gaynor, Rina Marachi, and all that, which is the first time that those have ever been identified as individuals of particular importance to the claimant's case. Now, and this is all covered with the submission that, well, it's up to the defendants to work out what's important. And that is just a wholly unrealistic submission. What we have is a roving review brief, which starts with, we want absolutely everything and nothing less is good enough, to, as we get closer to a hearing, suddenly, all of a sudden, we get very much more focused requests and even new ones coming up in oral submissions. And it's my own friend says, well, you know, we're creating difficulties here, but one just has to put oneself in the shoes of the litigators who are trying to deal with these requests and realise that this is obviously going to cause difficulty. I am instructed that we are content to provide broadly the information that has been the narrow request in relation to the fifth defendant. And I'll come back to that in a moment. But as to your lordship's question, I think you answered it about senior managers, about board members. Your lordship spotted it that they're not recorded. Why? Because they're not client facing. So some of them happen to be relationship managers. I believe that Mr. Carton is, for example, and so he will be picked up, but only in relation, presumably, to some of his calls. But in any event, to that extent, he will fall within the narrow-focused, more focused request. We would say it ought to be subject to the 30-second rule that the claimants have imposed on themselves in their review. But subject to that, our best estimate is that it will take a month to 6 weeks to get that documentation together. Why does it take so long? Well, for the very reason that my learned friend says that his client is not even going to undertake that sort of exercise because it's disproportionate, which is that it is a time-consuming process to identify who those people are, then go through the records and find the relevant data by reference to telephone numbers and so forth. It requires individual institutional knowledge. My solicitors can't do that by themselves, so they need to find the right people who can help them do that and undertake that process. But we will do that if that is it. What we can't have is a sort of roving request that carries on all the way through hearings and comes out the other side. We need to have a settled population of documents that we can just do our review on. Otherwise, this is going to be expanding on into well into the next year, even further. In relation to the question, what is the date range? My own friend told you well, they've asked us and they don't know when these people joined. In fact, it's pleaded, if you look at page 180, paragraph 61.4, the fifth defendant hired the private banking team from the Bank of Singapore's office in Dubai, which joined the fifth defendant in around May 2014. So at the moment, that is what we know about the date range. That's the effect of the date range that they are seeking. Unless there's some other suggestion for a date range, my submission would be that your lordship should fix a date range in relation to this, rather than do it the way the claimants have proposed, which is that we have to go back and unearth a whole set of facts about specific dates and then do specific searches in relation to each individual. There should just be a date range, and it should go from May. In relation to the claimant's audio, the issue is simply whether or not they give the disclosure they've already agreed to give, but extend it back from the 1st of April back to the beginning of 2014. So that's the issue between us. So my own friend says, this is paragraph 94 of his skeleton argument. He says that their proposal is that they will provide their audio subject to the 30-second rule between the 1st of April 2014 and the 8th of February 2015. So just under a year. We say they should provide January, February, March of 2014 as well. Now, nothing has been said whatsoever about it's not even asserted that would cause them any difficulties. They just resist it because they say, well, it's not part of the case, but it is part of the case, because part of our case relates to the agreement between the shareholders as to what was going to happen to these organisations. And if you turn, for example, to page 3757, you see their documentation being sent on the 23rd of January to Mr. Walia of Alpen, authorising Elie Sassoon to negotiate on behalf of BJSS. So you've got an advanced stage of discussions between these people, and we say that the audio files that are to be produced may well shed some light on the preparations that were being made in light of those advanced negotiations for what came to be described as a divorce by Mr. Walia. Now, it's all very well for my learned friend to say, well, they're wrong about that, nothing interesting happened in that period, but it's our case that something did happen in that period, and my learned friend can point to no explanation as to what difference it will make in practice to his clients to produce the slightly wider date range that we are asking for. So I would suggest your lordship should err on the side of caution in relation to that. My lord, unless there's anything else that I can help you with specifically, those are my submissions in reply.
Thank you very much. Right, well, I'm going to make an extempore ruling now. The defendants seek today an extension of time for disclosure of documents that have previously been ordered, and consequent adjournment of the trial, which is fixed for the 27th of October with a 2-week duration. This court originally set a timetable on the 19th of April of this year, allowing for 18 months until trial in October 2025. That should have been sufficient on any view for a trial of 2 or 3 weeks, as the case might be, which was the duration canvassed at the time. I return to the question of duration later. The parties, as it appears, entered into without prejudice settlement negotiations following the order made at that CMC. The pace of disclosure was slowed by agreement. There is a dispute between the parties as to whether or not, as part of the without prejudice negotiations, there was an agreement that the defendants need not appoint an e-disclosure provider. At all events, no such provider was appointed until October 2024, a delay of some 5 or 6 months, which has meant that the parties have been playing catch-up on disclosure ever since, and this has resulted in a number of interlocutory hearings. Since September 2024, there has been the usual allocation of blame by one party on the other in relation to disclosure and the delays that have occurred in its course. A further factor which is featured in the issues which arise for timetabling is the potential need for the assistance of foreign courts in relation either to the giving of evidence or to the disclosure of documents. Particular attention has been drawn to the Swiss banking secrecy laws in that context. I'm not very impressed by the suggestion that foreign restrictions on disclosure are or were ever likely to be a major problem here. The point was raised early on and has been discussed from time to time at the CMCs and the potential issues that could arise in relation to them. Initially, in orders made, any letters rogatory or requests for assistance were to be provided in draft to the court by the 12th of July 2024, and disclosure was to be effected by the 8th of November 2024, and the two were not, in the submission of the defendants, interlinked as such. It now appears from the material put before the court, upon which it can take no definitive view, but has always seemed likely to be the case, that the fifth defendant is not going to be bound by any banking security restrictions. The terms of the AGBCs of the fifth defendant provided by the fifth defendant to prospective clients include a waiver of Swiss bank secrecy requirements. There may be scope for argument as to their effect because of their potential width, but on their face, the waiver appears good. It also now appears that the termination agreement of arrangements between the first claimant, which led to transfer of business to the fifth defendant, and which were addressed to the fourth defendant, provided for a similar waiver. The court is disturbed that these matters have not been canvassed properly in the evidence that has been adduced by the defendants to this court, and in particular the evidence of Swiss law, which very specifically does not deal with any questions of exemption from bank secrecy law or any waiver of this kind. The claimant and defendant originally considered that 3 weeks was the appropriate duration for a trial of this matter. That was on the basis of 3 witnesses for the claimant and 5 from the defendants. The court suggested that 2 weeks would do. The claimants appeared to agree that was workable, and as I understood it, the defendants did not seriously demur. The defendants now say that they want to call 12 witnesses without identifying those concerned, and say that a trial of 5 to 6 weeks is required. At the case management conference on the 10th of June, the defendants gave their own estimate for trial at that time of 10 to 12 days. The defendants now say a trial of 5 to 6 weeks is needed, with a timetable which allows for 4 days for opening, 10 days for witness evidence, 4 or 5 days for experts on foreign law and valuation, and closing submissions of some 6 days, with possibly a gap between the end of evidence and the advancement of those closing submissions. Now, that appears to me to be a considerable over-egging of the pudding, particularly if the judge is given pre-reading time, which in a case like this is essential. It also seems to me highly unlikely that the defendant will call 12 witnesses, particularly when they are not identified, and I regard the suggestion that that will actually occur with some skepticism. Nor, it seems to me, is there any likelihood of a need for expert evidence to last as long as is suggested, nor should opening and closings take 10 days between them. On the face of it, it does seem to me that 2 weeks is not likely to be enough, however, and that 3 weeks looks a more realistic period of time. And for the sake of argument, I'm content to work on the basis that 4 weeks may be required plus judge reading time. But bearing that in mind, I should say now that I accept that the defendants cannot complete their disclosure properly by the 31st of January of 2025. Whether or not the claimants can do so is also a matter of doubt, despite Mr. Braganza's witness statement, which expresses confidence that this can be done. The defendants have embarked since the commencement of these proceedings on a course of conduct which appeared to be designed to avoid this matter getting to trial by one means or another. There have been delays even after their attempt at a stay failed. The failure to appoint a disclosure provider, whether something was agreed or not, has certainly led to the kind of delay which has rendered the trial incapable of being dealt with if a sufficient period is left between the completion of disclosure and the trial date. At the time of the CMC in April, the timetable envisaged was that with EDQs to be served in May 2024, the parties would have finalized search parameters, including keywords, custodians, and dates, by the time of the further CMC to be held on the 23rd of September, when any outstanding issues on document production or calling of witnesses to give evidence, whether relating to foreign law restrictions or otherwise, would be resolved. At that September CMC, the ambit of disclosure sought by the parties had widened to include a much larger and wider range of custodians than previously suggested. The court ordered searches of documents for a total of 54 custodians on the part of the defendants, and extended the date for completion of disclosure to the 31st of December of this year, whilst expressing doubts as to whether this was a process capable of achievement. A further hearing concerning disclosure took place on the 6th of November, which was unsatisfactory because the parties were at odds on the parameters for searches and had, like ships passing in the night, produced rival proposals on which the other party, and in this case particularly the defendants, had not had an adequate opportunity to comment before arriving at court in the morning. I then gave directions with a view to the parties coming before the court today and tomorrow, having done what they should have done long since, by, in fact, the time of the September CMC. The parties were to meet and agree parameters with only such limited areas of dispute to be referred to the court at the hearing today. Whilst not surprised to find that things do not appear to have progressed as they should, the court expresses its disapproval today that this is the case, having given the parties every opportunity to cooperate as parties ought to in the conduct of this kind of litigation, particularly in the context of disclosure. It is hard for the court to determine where the blame lies for delays since October 2024, and that is not perhaps as important for the moment as to whether a fair trial is possible in a 2-week window in October 2025, as currently scheduled, following completion of a disclosure exercise which is recognised to be of importance, in particular in the light of the nature of the allegations which are being made. Stepping back for a moment, a trial in 11 months' time from today would, one would have thought, be feasible in the vast majority of cases where pleadings had been completed and extensive interlocutory hearings, including strikeout applications, have already been determined. The parties are familiar, have been familiar for a long time with the ambit of the dispute, however dated the events which gave rise to it, largely in the period 2014 to 2016. I am left in no doubt that the defendants have not shown the diligence that they should have done until comparatively recently. In particular, they failed to provide metrics for various word searches or keyword searches to enable refinement of the search terms until comparatively late in the day. The result of applying the claimant's keyword searches as compared with those that the defendants wish to apply to their own custodians' documents is set out in a 56-page witness statement of Miss Martindale Howard, her fourth witness statement in this case, with its annexes. Paragraph 40 onwards deals with these issues. Floors and ceilings have been suggested, and indeed were suggested at the 6th November hearing. At that hearing, I suggested that they should be considered by the parties in relation to individual categories of documents, because it seemed to me obvious that there would be particular classes of documents that were likely to be of greater criticality in the context of this dispute than others. Floors and ceilings might therefore be appropriate for certain classes of documents, but not for others. And the parties were, I hoped, to direct their attention to that in the context of applying such measures to those documents which the parties thought had been appropriately identified as suitable. It seems that it was not until the 12th to 15th of November that the parties exchanged the necessary metrics. As might be expected, the number of hits derived from applying the defendant's keyword searches to their own documents were significantly less than those obtained by using the claimant's search terms. There followed a meeting on the 20th of November, and it now appears that much the same position holds good in relation to the claimant's documents. According to Ms. Martindale-Howard's fourth witness statement, so far as concerns the defendant's documents, the position appears to be as follows. There are 130,000 documents from the fourth defendant's hypersuite system, which have still to be extracted and processed, though it was thought that by the end of November that would occur, and there appears to be a considerable measure of agreement that the standard form documents that are contained in the hypersuite will probably not advance matters much and may be speedily dealt with. Of more significance, however, is the question of the defendant's audio files, upon which there have been very late developments even in the last day or so. Now, the estimated time, according to Ms. Martindale-Howard, for the collection and transcription of the defendant's audio files, reviewing them all, I'm sorry, I shouldn't use the phrase reviewing. Let me start that again. The estimated time for the collation and transcription of audio files on Ms. Howard's evidence is 2.5 to 3.5 months, with review of those transcripts estimated to be 175,000 to 200,000 pages in all, being a major task. On the basis of the defendant's prior estimate of 20-person reviewers of at the rate of 1,000 documents per week, that would take some 9 to 10 weeks of work. The defendants say that such a search would be disproportionate and unreasonable. Since the critical issues relate to recorded conversations between RMs and clients about transfer of clients, it is clear that the most material telephone conversations are, as is now common ground, I think, those to be found in the claimant's own documents and the fifth defendant's documents. So the scope of this exercise in relation to the defendants can be much more limited. In the last day or so, that has become clear from what the claimants have said. In the limited time available, I was told by Mr. Montague Smith, if I have noted it correctly, that it would take something between a month and 6 weeks to collate the relevant documents. But the extent and duration of the whole exercise is still unknown, even with this more limited range of audio materials. Hard copy client file documents in the possession of the fourth defendants have yet to be collected, though it seems that most will be duplicative of electronic documents to be disclosed in any event. The fourth defendant's custodial hard copy documents have not yet been uploaded onto Relativity for review, or at least had not been at the time of Ms. Howard's witness statement. The fifth defendant's custodial and non-custodial documents are on Relativity and available for review, but review had not at the time of that witness statement yet begun. A number of calculations have been put before the court by both parties on the basis of what is said to be a realistic rate of review and the number of reviewers who can reasonably be expected to be involved without loss of efficiency because of problems of uniformity in application and adequate knowledge of the issues in the litigation. In the defendant's skeleton, it was said that a first level review of documents, depending on the keyword searches employed and the number of hits, would take, even on the claimant's estimate of the time taken to review documents, some 2.5 to 3.5 months, meaning it would not be complete until sometime in March 2025, if begun tomorrow or the next day. If 50,000 documents were to be the subject of final review, on a best guess basis, that final review would take 2 months from the date when the CAL was trained to be ready for disclosure or an application for mutual legal assistance. If 75,000 documents were to be the subject of final review, it would be 3 months rather than 2. That would take us to June 2025 or thereabouts. However one looks at this, and the more recent figures I obtained on request from Mr. Montague-Smith, was that first level review would take some 3 months, and everything beyond that might take another month, and that looking at in the round, it was a 4 to 6 month period to completion of disclosure as the defendants currently saw it. On that basis, the 31st of December 2024, which is the current deadline for completion of the defendant's disclosure, is not feasible, and actual completion is some 6 months away. Therefore, the defendants maintain that the court should vary the deadline to provide for disclosure to be complete, and if the lesser of their estimates was taken, the deadline should be something of the order of 31st March 2025. To be on the safe side, and if 7 months were allowed, the deadline would be the 30th of June 2025. No application has actually been made for an adjournment by the defendants, but that is simply a matter of form, because it is an inevitable consequence of extending disclosure to either of those dates that adjournment of the trial would be required. There are many variables discussed, as I have already indicated, in the context of the time which is required. And Mr. Shivji, for the claimants, has said that the defendant's approach is wholly unreal, and that if they buckled down to it and applied themselves properly, the disclosure necessary would not take anything like the time in question. He referred to the assumptions which underlay the estimates, both in terms of the rate of review and in relation to the number of reviewers involved. The effect, he said, would be to cut down the time by a huge amount, so that, for example, 20 find it. Make sure I get this correct. Saying, for example, that a 21-week delay became 21 days for completion of particular elements of the exercises. The defendants also say that the claimants cannot meet the 31st of December deadline themselves. And it may be that in stating their agreement to an extension to 31st January 2025, the claimants tacitly accept that this is the case. If the claimants' own document population to be reviewed after deduplication and email threading and CAL is reduced to something of the order of 200,000 documents, that is said by the defendants to be 40 days work for 10 level 1 reviewers at the claimant's estimate of 500 documents per person per day. There remain, moreover, hard copy documents, according to the claimant's letter of the 5th of November, which have yet to be uploaded. They are to be reviewed manually, which the claimants are currently doing. It is said that the claimants have yet to obtain documents from former directors of BSA who were appointed by Alpen, but lawyers acting for those directors have said in writing that all their documents had already been provided to the liquidator. There are issues about the former liquidator's data room, and the same issues arise in relation to audio recordings as arise in relation to the fourth defendant's and fifth defendant's audio recordings. The position does not appear entirely clear, although Mr. Sampson took me through the steps which he said are in process now. All of this is very late in the day, however, and the question of disclosure of audio recordings on both sides remains a significant unknown. The defendants say it looks like the claimants are several months off completion of disclosure themselves, drawing attention to the hard copy documents position and the situation relating to the audio recordings to which I have already referred. I anticipate that the hard copy documents are unlikely to present much of an issue in that context. It is worth here referring to the question of the mutual legal assistance process. Mr. Besson is the Swiss law expert whose evidence has been adduced at the last moment by the defendants. He says it is essentially a 6-month process to obtain such assistance from Switzerland. There is, as I've already indicated, a real issue as to whether it may or may not be necessary at all in the light of the waivers to which I have referred. The defendants appear to say that assistance is required from Gibraltar, Monaco, Hong Kong, and Luxembourg, and possibly Singapore. But there is no evidence before me that there are any particular difficulties that arise out of banking secrecy or criminal prosecutions in the event of some form of disclosure being given. Where documents are involved in the mutual legal assistance process, those documents do have to be identified for any application to be made. If there are objections on issues of criminality, which have not yet been shown to be the case, there is therefore no basis as yet for any provision for any such steps because the need is not evidenced. But the court does have to bear in mind the possibility, in considering the timetable towards trial, to ensure fairness to both parties, to all parties. The court would not want witness statements to come in 2 batches if that was avoidable, because that would be inefficient. It seems to me almost inevitable that disclosure will not only be an ongoing process, but will, if such an application is required, involve at least 2 batches. If the defendant considers that it will need to apply for the court to issue a letter of request concerning documents or witnesses, it should make the necessary applications as soon as it is in a position to do so. The defendants have said that no fair trial is possible before late May 2026 at the earliest because of these factors. And that would be on the basis that disclosure is completed by March 2025, and a trial would have to be later if it was ordered to be completed by June 2025. The claimants rightly say that the adjournment of a trial, which has been fixed, is not a matter that the court readily countenances, but I am persuaded that the disclosure exercise, which was delayed in its inception by some 5 months and has proved more complex than anticipated, together with the need for a longer trial than was anticipated, require, in fairness to both parties, that the deadline for completion of disclosure should be extended and the trial date adjourned to a date sometime in 2026. Given the 5 to 6 months delay before the process of disclosure was begun in earnest, a 5 to 6 month adjournment would mean a trial in the summer of 2026. The claimants are keen to obtain full disclosure because of the nature of their case, and it seems to me that the audio recordings on both sides of the fence are likely to be of critical interest, and much more likely to be so than many of the other categories of documents, because of the natural tendency for any wrongdoer or alleged wrongdoer to avoid a paper trail which might incriminate him. The disclosure exercise must be done properly, and the suggestion of an arbitrary review cap of 75,000 documents, a floor of 250 documents, or a ceiling of 3,000 documents hit by use of a particular search term is not, in my judgment, justified. Floors and ceilings may be useful in seeking to refine search terms to ensure that a large number of irrelevant documents are not caught, but this should be the subject of discussion and agreement if possible, and not take the form of an arbitrary cutoff in the use of a search term per se. The additional time which I am going to order should allow for such matters to be properly explored to the extent that they are left undecided at this hearing today or tomorrow by decisions that I take in relation to search terms, should the parties wish me to do so. The defendants complain of the claimant's disclosures and the information sought at paragraph 33 of the defendant's draft order, as well as the inclusion of Mr. Kerman, a director appointed to the first claimant by Alpen. The issue is whether or not the first claimant and the previous liquidator and the current liquidator are giving full disclosure of documents in their possession or control. On the face of it, documents in the possession of a director are in the control of the company of which the individual is the director, but I have not yet heard argument about the position of Mr. Kerman, though I have come to some provisional views about it. I've also come to some provisional views about the other areas of complaint and the request for information, but again, I will hear submissions on that. And none of those particular matters appear to me likely to present any real problem in relation to future timetabling. So I base my decision on the matters to which I have already referred as being important. It is in these circumstances that I consider that there is ultimately no real prejudice to the claimants in some further months' delay to a matter that depends on facts already 8 years old, and that it would be better if adjourning the trial to fix a date for the trial that ensures that there is sufficient time for all the steps that may be required, including the obtaining of foreign courts' assistance, should that be necessary, as well as ample time to complete the disclosure process properly, without arbitrary cut-offs of the kind I have mentioned. Although the court is concerned and has expressed its concern that the disclosure process could, or indeed may have already become the tail that wags the dog, that this case might very likely turn on the disclosure of documents which record what occurred, and indeed, no doubt, inferences that may be drawn from those that do exist and those which do not. My inclination is therefore to refix a trial of 4 weeks for the autumn of 2026. That is delaying the trial by the better part of 10 months. I would fix a timetable likewise for disclosure that gives no one any excuse for non-compliance, with a period which allows for requests for the assistance of foreign courts, both in respect of documents and witness statements, even though I can currently see little need for such requests on the evidence available to me. Thus, subject to the parties addressing me on minor refinements of the date, where I shall give them the opportunity to do so, I would set the 30th of June 2025 as the date for completion of disclosure and for any letters of request to this court in respect of documents and witness statements, without in any way providing for any restriction of disclosure by reference to such issues. I will not make any order of the kind sought in paragraphs 8 and 9, and to the extent that paragraph 6 details it also, as they appeared in the defendant's draft order, because I have already made orders for standard disclosure in the English sense of the word, and these matters have been debated in the past. Furthermore, any such order could preempt any argument as to the real need for letters rogatory or the effect of any acceptance, refusal, or lack of attention to any request that was made to a foreign court for assistance. All those matters will remain open for debate. I will, however, allow a sizable interval before service of witness statements and expert evidence for the trial, by providing that both witness statements and experts' reports should be served in March 2026, with timetable thereafter following the lines of paragraphs 12 to 19 of the defendant's draft order. A trial date will, again, subject to any minor refinements which the parties might suggest, would be the 7th of September 2026, with 4 weeks set aside. There will be a need, once again, to set dates for CMCs in 2025 and 2026, and to do so in short order, and also for a requirement for notification to the court of the identity of witnesses whom the parties intend to call. They would not, of course, be bound by that intimation, but it would be an indication to the court which will enable the court to see just how much time is really required to be reserved for this trial. Within 2 weeks of today, therefore, the parties are to provide each other in the form of a list with the name of witnesses they currently intend to call, with a copy filed with the court. I think that covers the ground so far as is necessary on the matters that have already been the subject of submissions. That leaves outstanding particular areas of disclosure relating to Mr. Kerman and the material in liquidators' hands. The exact details of the timetable and the form of order and the whole question of search terms, which I have no desire to embark on, but will, if necessary, during the course of this afternoon and overnight, so that matters can be dealt with tomorrow. Will the parties now tell me what I have omitted and what, so far as they're concerned, remains to be done?
My lord, thank you for that. Can I, so I don't believe you've omitted anything. Can I suggest that overnight we put together a draft order with the timetable in light of you just filling in the detail
Yes.
following the structure your lordship has given? Does your lordship have a view on the reading time that should be allotted? It's probably a matter for your lordship as to how much reading time should be allotted for the trial.
Well, provided I've picked a Monday, I think I have it, though I have some suspicion it may be the 6th rather than the 7th. Let me just check that. What I had envisaged, right. Which is it, Mr. Montague-Smith?
It is a Monday, the 7th.
Monday is the 7th. What I had envisaged was that I would have a week to read in, which is why I'd picked the 7th.
Very good.
That's what I was hoping for, and this will be a trial that takes place in Dubai. I'm bound to say, of course, I'm very loath to be setting aside 5 weeks out of my diary when the actual duration is uncertain, depending on exactly who does come to give evidence and so on and so forth, which is why one reason why, from a personal angle, I would be keen to be kept up to date on any developments in that regard, counsel being well aware of their duty to keep the court informed of any developments in that respect. But you'll appreciate that if matters go short, unlike in arbitration where there are such things as booking fees, international judges in the DIFC do not get remunerated on such a basis.
Yes,
clearly
normally judges would use that time to write the judgment, but I think we've seen the speed with which the amount of time required can be limited.
The reality is that I shall have to set aside a week after the hearing to write the judgment. So this is going to take 6 weeks out of my diary.
Well, we're great, my lord. We're grateful for that, and obviously, as you say, we do have an obligation to keep your lordship informed on the time estimates. It may be that one hopes that the process you've envisaged with the identification of witnesses may mean that the estimate can be reduced a bit, but so be it. So, my lord, we'll do that overnight.
Yes.
In terms of, I mean, we've heard what you've said about the keywords, and I do. This is going to be dealt with on our side by Mr. Sampson, but I suggest that it is worth just the parties exploring overnight whether, given the revised timetable, there is now more time to get a full exercise done. And your lordship has previously said how critical a disclosure is in a case like this. So it may be that some progress can be made overnight, and if there isn't, the parties will have to explain themselves to you tomorrow on that. Similarly,
I think that would be sensible. What I don't want is simply because everything has gone off into the long grass, that we have a perpetuation of further arguments between the parties as to what has and what has not to be done. And the whole point of today and tomorrow was to try and bring finality so far as possible, so that I am quite prepared to grapple with whatever has to be grappled with tomorrow to bring some degree of finality to the process, so that everybody knows where they are, and we don't have to come back and have yet further arguments about the ambit of disclosure. I don't know to the extent to which those involved are in the UK and therefore have the rest of today, so to speak, to discuss matters between them, or those are in Dubai who have much more limited time because it's tea time in Dubai now.
Well, my lord, we'll explore how best to do that and which which connection is the most likely to be the most fruitful. But I suggest that we try doing that overnight. I mean, your lordship's comments have been well heard, and I have said this before in this case, but this sort of process is much less painful if there is a high level of collaboration between the parties, because the issues are thrown up in disclosure all the time, and we can't always come back to court to resolve every piece. So we'll see what we can do overnight, and we will put together an order. We'll take carriage of that and circulate it to my learned friends to have a look at. Based on past experience, it is worth going through the order with your lordship tomorrow to make sure that we're all clear. We can make that and put that to bed. And then tomorrow we'll deal with keyword searches, maybe a brief word on the custodians, but we'll see where we get to on that. And then it's those information requests, which are quite limited. And then just a short point about Mr. Astrup and Mr. Gribbett. So the agenda for tomorrow, it does not look that heavy, and I'm hoping that we can get it done swiftly.
Well, the only question that arises is whether I need to be trying to grapple with all the differences between the parties on keywords. Do I need to be looking at all that material that was attached to the skeletons or not?
Well, I think, Pat, can I pass that over to Mr. Sampson on my side? I mean, for my part, I don't think that's a very fruitful use of your lordship's time, but we will, if Mr. Sampson could just come in on that, please.
Thank you, Your Honour. Yes, well, I agree. I don't think it would be a particularly fruitful use of Your Honour's time, nor really is it something that the court ought to be required to do, and the parties ought to be able to, I mean, obviously the parties have heard what Your Honour has said, and obviously take into account the time that now exists in the timetable. But secondly, the advocates should be able to deal with matters at a higher level than descending into 86 pages of schedules orally.
Is that an agreed position, Mr. Montague-Smith?
I think so. Mr. Conte would be dealing with these issues, but it's not easy to get him on camera, so I'm conveying the impression, which is there's probably still merit in having a discussion about the high-level points, or some of them.
Yes.
You've given us some indications on some of those issues, and we'll take that away. I don't think we do not consider that it is worth you getting into the weeds of the specific differences on drafting at this stage. Is that, someone will tell me if I'm wrong, but I think that's our position.
Right. So I'm not to look at search terms with asterisks and the like and decide whether that's appropriate.
I don't think it's going to advance anything materially. I think it won't. I'm not sure it's going to be. I mean, you'll be very much on your own if you do, I suspect, and feel very much on your own if you do. It seems to me that, look, if there is a need to look at any of these, it's something that will need to be done together, if I can put it like that, in the course of tomorrow. So there may be some large numbers that you might want to take a look at and see whether or not there are competing proposals for refinement of individual discrete issues. But I would hope that you'll be guided through those. I don't think it's going to be helpful for you to spend hours and hours and hours looking through 80 odd pages of markup.
All right. Well, that's that's a relief. Thank you. So what else do we need to do today? Nothing for the moment. Is that right? You will absorb what's been said and talk to one another. My
lord, there's just one thing arises from your lordship's reasoning, and it just a clarification from our side, just to make sure that everything is understood. In relation to hard copy documents for the fourth defendant, this is. I think your lordship said progress was being made to transfer documents, but there seemed to be a high degree of duplication. In fact, that puts together two categories of hard copy documents that we have for D4. So D4 has client account documents, and then there are other documents which are all hard copies. In relation to the client account documents, those have been checked and found to be duplicative already. And so we do not propose to incorporate those documents into the search at all. We've said that, and as far as I understand it, there's been no pushback on that. So that's the position. They've been searched to that extent. As to the remaining hard copy documents, those are the ones which were identified in custodial interviews, and there are some that still need to come from Switzerland, but that's in train. So I just wanted to clarify that point in case anybody suggested that there were documents that were to come that were client account hard copy documents from the fourth defendant.
All right. Well, that's helpful. Good. Well, I think then we draw stumps for today, and I suppose Mr. Shivji opens the bowling tomorrow morning, does he?
Yes, my lord, but we'll keep it brief.
Yes, as have been the Australian innings of late, I note.
we have an Australian member of our team, but I'm sure it's water off a duck's back by this point.
Mr. Devonish, yes.
I'm Mr. Conte.
Yes, quite right. Yes.
Well, as an aside, I had to make clear to the Court of Appeal the other day, I'm also Australian. So there was a point at which offence was being taken about the attitude that I was transmitting towards Australian jurisprudence. But I also hold a passport. So.
Gracious me, I had no idea. I'm Australian jurisprudence is, of the other countries in the world for which one has respect, Australia is one. The decisions that come out of Australia are, to my mind, by and large, very sensible indeed. And I don't say that simply because the Chief Justice in Dubai is an Australian.
Well, I think you're outnumbered now in Dubai, but there we are.
I think that's right. Well, there we are. That's life. All right. Well, thank you. Thank you, everybody, very much for all your hard work. And I will see you at 8 a.m. UK time, midday Dubai time tomorrow.
Thank you.
Very good. Thank you very much indeed.